I say everybody. Um, I say everybody because, in fact, I don't think everybody is here yet. We're having a very early start compared to what we usually do, starting at 10. But we have such a varied and full program, as indeed can be seen from the brochure, which runs to more than 250 pages. We've got a lot to cram in today. Well, my introduction will only take 3 minutes according to the timetable, but I just want to say a few words about how the speakers are going to be talking to you. Now, you're very welcome to type any question or comment either in the chat box or in the Q&A box at the bottom of the screen, and the speaker will endeavor to answer your questions. Now, that could be done either during the talk. Some speakers like to pause and answer questions then, or else they will wait till about 10 minutes before the end and then run through the questions. But we will do our best to answer any queries that you have. Now, the first speaker is Seema Kansal of 14, which I think used to be 14 Gray's Inn Square, but barristers' chambers these days are adopting shorter, snazzier titles. Well, Seema, I'm sure your talk will be snazzy, if not short, and very interesting. So without further ado, let me transition seamlessly to Seema Kansal. Thank you.
Thank you, Richard. Good morning, all. I'm going to now share my screen where I have some slides. I think there is a message in the chat box that needs addressing. Well, I hope that kicking off this webinar today, that you do find this topic interesting. It is an important topic, child maintenance. Often it's seen together in relation to other issues, but at times child maintenance does creep up as a sole issue in itself. Many of you will have most of your experience dealing with child maintenance under the Child Maintenance Agency, Child Maintenance Service, sorry. And most of those applications and the calculation of quantum will be dealt with under the Child Support Act. So I'm just going to flip my slide, sorry. So as you know, the legal framework and the majority of my talk this morning is going to be in relation to the cases that isn't dealt with under the Child Support Act or through the Child Maintenance Service. In terms of the legal framework, you know that you will be looking at and dealing with the Matrimonial Causes Act 1971. And often those cases will be applications for lump sums and spousal maintenance. So child maintenance will be in addition to that. If the parties are not married or civil partners, then you will be looking at Schedule 1 of the Children Act 1989. And as I say, the Child Support Act 1991, in relation to the cases that come before the courts, is relevant in terms of looking at when the court actually has jurisdiction. And I've also just put in the other statutory instruments that are relevant. So when does the court have jurisdiction? As I say, most of the cases, the assessment of child maintenance will fall within the jurisdiction of the Child Maintenance Service, and therefore the court's powers are generally OTOs. But and that's in relation, and as I say, I've given notes, but I've put in Section 8, subsection 3, which states again curtails, if you like, the powers of the court in relation to child maintenance. So when does the court have jurisdiction? Well, firstly, where the parties have reached a written agreement about child maintenance and it's recorded as an order of the court. And we know that if that's the case, the court will have the power to vary an existing child periodical payments order. And sometimes we see in an order that parties record on the face of an order a nominal payment, periodical payments order, which again confers powers on the court in relation to variation later down the road. In any case, the courts will have jurisdiction. In any case, where initial order has been made, that could be superseded by any child maintenance application that's made more than 1 year after the order. So, and that's typically where a party, the party that's receiving payments feels that actually there's been a change in the circumstances of the child that warrant the variation. So, secondly, when does the court have jurisdiction? When the child or the parent with care is habitually resident outside of the jurisdiction of England and Wales. And we know that in those cases, the CMS has got no jurisdiction to make any child maintenance orders. Thirdly, where the facts justify a top-up order, we'll deal with that later in the talk, and that's where the child maintenance service, the maximum cap has been reached. So that's where you're dealing with a gross income of more than £156,000, so more than £3,000 a week. Where a school fees order is sought or payment is sought to meet expenses incurred in relation to training or education. So if that's the case, you would be seeking recourse through the courts. If payments are sought in relation to a child's disability, again, your client will be seeking to go through the courts. And again, if the child reaches the age of 19 and is still in education or training, so tertiary education expenses there, again, you would be seeking the jurisdiction of the courts in relation to that. So how applications are made, as we've said, under the MCA or Civil Partnership Act 2004, or if you're dealing with unmarried partners, as we say, under Schedule 1, where the non-resident parent's income is over £156,000, we know that the court has jurisdiction to really interfere. So dealing with the first case, but it's Mr. Justice Mostyn, but as he now is, in GW versus RW 2003 High Court case, it was Mr. Nicholas Mostyn QC, sitting as a Deputy High Court judge at the time. That case involved, so again, court's jurisdiction was invoked, and the court did have jurisdiction by virtue of the child and the parent being habitually resident in Australia. So we know that in a case like that, the Child Support Agency, as it was at the time, didn't have jurisdiction to make a calculation. Now, in that case, the case was after the implementation then of the new child support regime in 2003. Husband's case at that time was that the figure for child maintenance should be 20%, so about 20,800. On wife's case, it was argued that the total cost of the children, excluding the school fees, was 152 Australian dollars. For husband, it was said it was 103,000 Australian dollars. I've put in a note as to how the calculation was approached. The judge recognizing, as is the case in many of these child maintenance cases, particularly high net worth cases, that the calculation was a rather arbitrary exercise. And the judge in the case assessed the children's costs as being just over 137,000 Australian dollars. And in that case, the judge identified 3 principles. And this is, as I say, an important case in relation to identifying the principles which are still maintained to this day. And the first principle was that the appropriate starting point for a child maintenance award that is obviously before the court should invariably be the figure that's thrown up by the Child Maintenance Service, so the calculation that's done by the Child Maintenance Service. And the reason for that, the rationale behind that, is that there needs to be consistency in the way that these cases are approached, so that everybody knows what the parties can hope to achieve under sort of child maintenance in the future. And that's particularly important where you are dealing with unrepresented parties. And Mr. Justice Mostyn, as he now is in the case, stated that if an order that's made by the court is markedly at variance with a calculation that's made under the child support regime, then there is a high temptation for a party to apply to vary it after a year and on giving 2 months' notice. And the second point was that notwithstanding that the income of the parent with care is disregarded in child maintenance calculations, of course, when you are dealing with an application under the MCA, it's quite more likely than not that a judge would have made a lump sum order, perhaps under the sharing principle, and the judge who is then dealing with child maintenance would be aware of that fact, that he or she has just made a lump sum order. That Mr. Justice Mostyn, as he now is, said that it would be reasonable to expect the parent with care who has received a substantial share of the party's assets to contribute to the support of the children. And the third point is that the figure of child maintenance should be in the currency of the payee, so that the children aren't exposed to a risk of inflation. Now, again, that the first principle identified in GWV RW being that the starting point should be the calculation by the CMS was again applied in the case of Dixon and Rennie. That was Mr. Justice Holman in that case. Moving on, again, Mr. Justice Mostyn in the case of TW versus TM, and that is a 2015 case, High Court case. Again, Mr. Justice Mostyn reaffirms his principle in GW versus RW, that the same principle applies to the new, as it was, 2008 regime. Sorry, just get back. So he reaffirmed his position, and he again restated that it would be an example of arbitrary lawmaking if the computation of child maintenance was radically different as to whether it was done by the Secretary of State for Department of Work or Pensions or by the court. And then again stressed that there should be consistency of approach, and there was obviously public policy reasons for supporting that. So that was again reaffirmed, as I say, in TW versus TM. And Mr. Justice Mostyn set aside in that case the lower court's order on the basis that she didn't identify any good reason why she was departing from the formula as a starting point. So now just moving on to CB versus KB 2019. Again, Mr. Justice Mostyn, and it's right to say that this is perhaps where the controversy began. In that case, Mr. Justice Mostyn was dealing with parties, a husband who was a musician earning just under £650,000 gross a year. And in that case, Mr. Justice Mostyn made a suggestion and stated that, again, using the figure, and it's obviously because he was dealing with a case where a party was earning just less than £650,000, but some may say it's an arbitrary amount, but did make the suggestion that where the gross income of a non-resident parent doesn't exceed £650,000, the starting point should be the result of the formula ignoring the cap on annual gross income at £156,000. So that was the suggestion that was made. And Mr. Justice Mostyn went further and said, well, if you are dealing with a case where a party is earning gross in excess of £650,000 a year, then you are in the world of discretion. So the starting point would be the formula, but then you are in the world of full discretion and freedom to depart from it, having regard to the scale of the excess. So in that case, other particular factors were, again, shared care. So that, as we know, would affect the quantum of child maintenance. Also, in that case, wife had been awarded half of the share of the matrimonial assets, being just over £5 million. And of course, as we know, that the court was expecting her to use that to meet her reasonable needs. And the suggestion that has been made by Mr. Justice Mostyn in this case, CB versus KB, has been applied by his brother and sister judges in many cases. As I've written, C versus G versus T, and we know Collado Fuchs. And I will go on to the cases that, sorry, I think I'm missing a slide, apologies. Right, well, I'll just have to move on. So, well, as I say, where the case was applied, Collado and Fuchs was 2022 case. Again, Mr. Justice Mostyn, dealing with an ultra high net worth couple in that case. There were other issues. There was a post-nuptial agreement, so that was an agreement that was varied after the prenup. Husband was a billionaire real estate developer, and they lived a billionaire lifestyle. There wasn't an argument about whether the post-nuptial agreement was binding, but there was an argument about child maintenance. This is a useful case, Collado Fuchs, for looking at how Schedule 1 cases are dealt with, even though it's a child maintenance case. So in that case, there was a maintenance order. Their maintenance was actually secured by way of a guarantee, because as we know, a guarantee doesn't end as it would do as a child maintenance order would do on the death of a payer. But there wasn't any other spousal maintenance claim in this case. As I say, there wasn't any argument about whether the P&A was enforceable or not. But the court did provide, in this case, very useful guidance about how Schedule 1 cases should be approached. And this case actually is the one that launched what we know as the HEXA, which is the Household Expenditure Child Support Award, the tongue tie. So it's developed what we know now as being the principle that it is permissible to support the child by supporting the mother. So in my note, I lay out, as I say, the important aspects of Collado Fuchs. It launched the HEXA, as I say. It provided important guidance on Schedule 1, particularly in relation to the case of J versus C. And what the court said there is that the criterion is the nature of the child's home environment and provides the obvious baseline. The reference to the child's home environment is to the home that the child enjoyed with both parents before the breakdown of their relationship. And what the court does there is draw the cases together and establishes the following principles, which I've laid out in my notes. But as I say, what's important there is that we are now looking at supporting the child by supporting the mother. And we are looking at the standard of living of the parties prior to the breakdown of the relationship, and ensuring that the the child's life with the parent with care versus the non-resident parent isn't out of kilter with its experience in life with the non-resident parent. And that is, again, a theme that we see that continues throughout the cases. So as I say, it's an important case to look at how hexas are applied. Sorry, I haven't paginated the notes, but under the case, as I say, of Colladar Fuchs, at point C, it says a hexa cannot meet those expenses of the mother which are directly personal to her and have no reference to her role as the carer of the child. An example is a subscription to a nightclub. However, the award can meet the expenses of the mother which are personal to her, provided that they are connected to her role as a carer. Examples are the provision of a car or designer clothing. So you can see that there is a whole range, a whole scope of argument there as to what would be permissible under hexa. And of course, it's directly relevant to the standard of living, the sort of relationship that the parties enjoyed prior to the breakdown of the marriage. The next case that I want to talk about is where the case of CB versus KB hasn't been followed. So Re-Z, a child number 4 Schedule 1 award. This was a case this year by Mr. Justice Cobb. Now, this was the final hearing before Mr. Justice Cobb of the mother's application under Schedule 1 in respect of a child who is aged 2, who was born after the parties' relationship ended. Husband had disengaged. He'd never met the child, and the child suffered from a significant disability, which was progressing at the time of the hearing, displayed with global development delay, speech and language, and communication difficulties. Mother didn't work, and she had very modest financial resources. And the husband, husband was an investment manager, described as immensely wealthy, had monthly outgoings of about £180,000 a month. The wife sought the mother sought a housing fund of £4 million on the standard Schedule 1 terms, periodical payments of £174,000 a year, and the provision of a nanny, and laid out her costs from the nanny. In that case, the father ran from the outset, and that was when he was engaging the millionaire's defence, which we know is the justification of providing limited or no disclosure on the basis that they can meet any award that might be made by the court. So father's position was obviously at odds with the mother, and the judge stated in that case that although noting the standard of living was not within the list of factors that had to be regarded under the statute, the judge noted the test set out in Hussein and Maktoum, where it was said that the children's lifestyle should not be out of kilter with that enjoyed by the parties before the relationship broke down. And we obviously have just seen that also in the case of Colladar Fuchs, where the court has made that observation in relation to Schedule 1 cases. And then Mr. Justice Cobb followed the approach of using a hexa in that case, but declined to follow the child maintenance formula as regards calculation of maintenance, noting that it had no relevance to the facts of that case. And he also explained, which he was right to do, that in the case of CB versus KB, Mr. Justice Mostyn had gone no further than offering guidance on child maintenance cases, stating that actually the child maintenance calculation is a useful starting point, but is obviously subject to an overall discretionary review. And in that case, the mother's position at the final hearing was her periodic payment should be capitalised because of father's failure to pay other aspects of the order. And the judge rejected that including the fact that periodical payments under a HEXA couldn't be capitalised unless absolutely necessary, given the possibility that the payments needed to be varied over time. And I've put there what the outcome of the case was. There was a housing fund, a sizable housing fund, redecoration. There was a fund for the child's special needs. There was a lump sum for moving costs. There was a periodical payments order for index linked for payments for a nanny, and a HEXA. So the next case is a wife and a husband in 2022. So that obviously, predates the case of Re-Z. In that case, the parties were married and they had 2 daughters. The wife petitioned for divorce, and her application for financial remedy was agreed by consent. And there was an order for periodical lump sums in installments, child maintenance and spousal maintenance. 2 years later, the wife applied to vary the order, and she sought an accelerated receipt of capital to rehouse herself and the children. And that was agreed by consent, but with a lower sum agreed as a trade-off for the quicker payment. Then she applied again 6 years later to vary the financial order. And at the hearing, she accepted she didn't have a claim for spousal maintenance, but in relation to the periodical payments for the children, her case was that they were now insufficient to cover her needs. And there was a significant disparity between the parties' lifestyle, and that she had accrued substantial debts. Husband cross-applied for a repayment of spousal maintenance that he had paid on the basis that she had been cohabiting with another person for a period. The wife in that case referred to the Mostyn formula in CB versus KB, and in that case, the judge rejected the formula by Mr. Justice Mostyn, and accepted the husband's submission that would be seeking continued spousal maintenance through the back door. So again, it's another example of where Mr. Justice Mostyn's very helpful suggestion was rejected. The next case is the French marriage contract case of CMX versus EJX in 2022. And this is Mr. Justice Moore, who didn't follow the case of CB versus KB for very good reasons. In that case, so Mr. Justice Moore's case, there was 1 child that was subject to an application for child maintenance. But we know in CB versus KB, there were 3 children. And what Mr. Justice Moore stated is that the formula that was used by Mr. Justice Mostyn in CB versus KB produced a very disproportionate, irrational result when dealing with 1 child. In fact, the calculation for using 1 child using the formula ended up being a lot greater than the calculation for using for taking into account 3 children. And what Mr. Justice Moore said in that case of CMX versus EJX at paragraph 81 is that he did accept, I do of course accept, the beauty of the decision of Mr. Justice Mostyn is that it makes it easy to calculate the figure, so avoiding disputes. There are, however, significant disadvantages. Sorry, there were 4 children in CB versus KB. So the wife got 12,600 per annum per child. Given that I have to apply Section 25, it is impossible to see why the wife gets 12,600 per child, but this wife in his case receives 63,000 for 1 child. Because the 2 eldest children in the case weren't part of the calculation. If they were, then the figure would have reduced to just over £21,000. So of course it was completely irrational for the court to approach the guidance by Mr. Justice Mostyn. And in James versus Seymour, as we know, Mr. Justice Mostyn accepted Mr. Justice Moore's criticism of his approach, and stated that actually, and as we know, had produced a different formula. But in relation to James versus Seymour, that was an appeal to Mr. Justice Mostyn in relation to the correct approach of calculating child maintenance. And in that case, the parties married in 2010, their marriage was for 2 years. They petitioned for divorce in 2013. There was a consent order. Mother applied for accelerated receipts. And the judge, and to vary the consent order, seeking increased payments of spousal and child maintenance, and submitted that the Mostyn form, under the Mostyn formula of CB versus KB, she should actually receive just over 2,000 a month. The judge at the first instance found that the children's needs had not substantially changed, and went with the husband's case, and the wife in that case appealed. And on the first ground was actually the judge failed to follow Mr. Justice Mostyn's guidance in CB versus KB, and that the assessment of quantum was therefore too low, and also the third ground being in relation to costs. Now, in relation to the first ground, which is that the judge failed to follow the approach, that the starting point for child maintenance should be the figure given by the CMS up to incomes of £650,000 gross. The judge referenced his own decision in TW versus TM, and that was that where the father's income for child support exceeded the statutory ceiling but wasn't unadjacent to it, the formula still would provide useful guidance. He also referenced his decision in Colladale Fuchs, where he qualified that the formula would be irrelevant where the claim was for the type of child maintenance, support maintenance award, which he described as a hexa. And he endorses that his formula provides a useful and logical starting point in a child maintenance case, where the income is more than 156,000 but less than £650,000, and the application doesn't seek a hexa, and where it's not a variation application. But he accepted the criticisms that the formula can produce varying results depending on the number of children in the household. So what the judge did in that case was came up with a new formula, and created a child support starting point, a CSSP, which is appended to the judgment. So if you want to look at the formula, it is there. The formula doesn't apply where there are 4 or more children and earnings are more than £650,000. Again, £650,000 being a rather arbitrary figure, but we know that once we're past that, we are in the realms of wide discretion. The formula doesn't apply where the husband's income is largely unearned or where husband is living off capital. And the AFM, which is the adjusted formula methodology, is a loose starting point where the decision maker can accept or reject without fear of appellate review. And that's, of course, very important, that we can expect to have decisions that are consistent and that are not continuously subject to review. So there is a new formula that produces a more realistic result. There, as I say, there are they're not applicable where there are 4 or more children or earnings of more than £650,000. There is a table that Mr. Justice Mostyn gives appended to his judgment, and it breaks down the child maintenance calculation. And between the brackets of the child maintenance brackets, you can see that there is a margin of error there. And actually there's the calculation is on At a Glance Cloud if you have subscription to that. Or there is an Excel sheet that has actually been prepared, is on the Financial Remedies website, and it is actually very, very useful because you can just type in the figures and the income that you're dealing with, and it will come up, it will apply the formula, and it will come up with the result. So if you can't find the Excel sheet, please just email me and I can send it along. It is hoped that this formula is going to produce, as I say, more consistent, reliable calculations, perhaps takes out a lot of work that otherwise is involved in coming up with calculations for child maintenance. As I say, should provide more consistent results for the sorts of cases that we see. So that is the end of my talk. I think I've finished earlier than expected. I'm just going to go to the chat box. I think somebody had raised a hand. If anybody has any questions, please could you just put it in the chat box or otherwise. It should be at the bottom of my handout. It is at the bottom of my handout. Oh, sorry, just. What about a case where wife and children are living in the UK, father is living outside of the UK, but he regularly comes and stays in a UK hotel? Well, the wife and the children are habitually resident in the UK. So on the face of it, the child maintenance service may be engaged. You want to look at the amount of income that you're dealing with in relation to the husband. Does it reach the statutory ceiling? And whether there have been any previous agreements between them in relation to child maintenance. If there have, then you would be looking at a variation. Well, if that's what you seek, or a variation. But also, I think what's important is, I mean, if they are married and they're now divorced, you want to look at which jurisdiction did they start their proceedings in. If it was England and Wales, then you know that the jurisdiction is here. So there are a number of factors to look at in relation to that scenario. Divorce proceedings are in the UK. Yes, so you want to look at, I mean, has there been a child maintenance calculation that's been done? Because we know that you have to have the child maintenance calculation in any event before you go to the court, in order for the court to then have jurisdiction, as we know in the case of TWS and TM. No previous agreement regarding child maintenance between them. Yes, so divorce proceedings have been, sorry, so if there's no previous agreement, as I say, you want to get a calculation done by child maintenance. How would the child maintenance calculated if the father is not working? What is the starting point? The children are 17 and 15. They've just arrived in the UK from Hong Kong and each have savings over £450,000. The criterion that child maintenance apply is, so, for want of a better word, very complicated. But I do understand that savings are very important. So the income of the receiving parent is irrelevant. So the fact that the husband will have savings over £450,000 is going to be relevant, even if he doesn't have a income. So for the children, you would be looking, as I say, to do that. There is a child maintenance calculation, which is in the Child Support Act 1991, and that provides a formula in one of the schedules. So you may want to look at the formula there if you want to. And there is also a child maintenance calculator online, which you can use, and it will give you a good idea of what the starting point would be. So I would suggest go and get on that calculator and put in the details to see what the result would be, particularly where you're dealing with only savings and no income. Thank you all. Thank you very much for listening.
It's about time I came in, Seema. I think there's been a problem with the chat box and the Q&A box, but you've been answering some questions anyway, so that's good. And well, I don't think that there are any more questions at the moment that I can see. Oh, just one, I think, in the chat box. I think it's saying thank you. Yes. So I don't think there are any more questions for you.
Thank you, Richard.
You must have covered everything, and a bit before time. So very well done. So Seema, thank you very much indeed.
Thank you, Richard.
And you're well within time. Usually, I have difficulty getting speakers to stop carrying on after they should have finished, but you were the opposite. So thank you very much indeed for a very useful and helpful talk.
Thank you.
And I think if we have Jo O'Sullivan waiting in the wings, she may be able to take over a few minutes early. And Jo, are you there? Oh, there you are. Would you be able to take over a bit early?
I will. Thank you very much. Thanks, Richard. Just to let everyone know, I have had a power cut while I was listening to Seema. If that happens, I will hop on to other things. So there might be a slight delay if it happens again. I live in the countryside in England, should say, but nevertheless, sometimes these things will happen. So I'm just going to get my slides up.
Okay, so perhaps I could just chip in and say, hopefully we'll have we have now got the chat box up and working, and hopefully the Q&As as well.
Yes, please ask questions as we go. Please do. Yeah.
Right, you are. And well, I'm particularly fascinated by the notion of a collaborative solicitor, not a hired gun, but somebody who acts for both parties in a family dispute. And it looks like a very interesting and fruitful development. So I'm certainly very keen to hear about it. So anyway, I'll take myself off the screen and let you start ahead, Jo. Thank you very much.
Thanks so much, Richard. All right, I'm going to attempt to share my screen with you all now, and I hope I can get the slideshow going. Come on then. All right, there you are. So what are we talking about today? This is the one lawyer, one couple process. I'm Jo O'Sullivan and of O'Sullivan Family Law. I have my own practice, which is non-court based, so I'll do anything that isn't court. So I'm not competing probably with any of you. I've pioneered this process. I've been doing it for about 1.5 years now, and I'm happy to share with you what I've learned. And what else do I do? I'm an accredited mediator, so I do my AMs. I mediate a lot. I work with other lawyers in the collaborative process, and I do four-way meetings. I support arbitration, and you'll be hearing later from Gemma Lindfield about child arbitration, which is wonderful. Obviously, I do four-way meetings, early neutral evaluation, and of course, I support child inclusive mediation. But I'm not here to talk about that today. All right, so my next slide then. Oh, look, I wrote a book. There you are. I wrote a book called Almost Anything But Family Court. I'm very happy to promote it. The proceeds go to only mums and dads who support parents going through a breakup, which is, let's not forget, a really traumatic time. And I hoped with this book, which is meant for our punters, I hope that this book would introduce a different way of thinking around divorce and separation, and that people would stop thinking about it in terms of a conflict, which most of the time people don't have a conflict. They don't have disputes quite often. They just have little problems that they need some help with. That's my view, of course, and you will know a different side of things. But please do have a read of it. It's got everything in there, including this process in short form. All right. So what is the one lawyer, one couple process? Okay, so it's where one lawyer is acting for the couple in their divorce or separation. The lawyer helps the couple reach a settlement, and if appropriate, will draft the legal documents necessary, for example, a deed of separation, or if they need a court order, with the court by consent. This work includes all kinds of matters that might arise from a divorce or separation, children work, private children work, financial settlements, trust of land, of course, and Schedule 1 of the Children Act, which our friend Seema has, our learned friend Seema has been talking to us about. What else can it be used for? Well, it may be possible to use the process to help with declaration of trust, or you may call them deeds of trust. But many of us may feel a bit squeamish about that, because we all know that the reason why deeds are so sexy legally is because they really work. So there needs to be no duress, no mistake, and no fraud. And can one lawyer possibly do all of that? It might be better that they do have their own lawyers in drafting those documents if you really want them to operate well. I would say you could go as far as doing pre and post nuptial settlements, but I had a meeting with about 30 lawyers who were working in this way the other week, and the word on the street is not to do that, because, as you know, again, the magic 3 for pre and post nuptial settlements, you need some delay between the signing and the wedding or civil partnership. You need independent legal advice, and you need full financial disclosure. But of course, can you give independent legal advice to two people? This is the big question, and this is what we must battle with, because the point is, isn't this a conflict? You know, straight out of law school, you know that you're not supposed to act for both. Sorry, the sun's coming in at me. You know that you're not supposed to act for both of the couple. Isn't it just an inherent conflict? I mean, yes, what used to be the answer to that question, and we were all happy with it, weren't we? And then we thought, actually, maybe there are some people this could apply to. So what are the rules? And they're in your brochure, but the rules are these. The Code of Conduct for Solicitors and Firms of particular interest are Rule 6.1 to 6.2, which may prohibit joint assistance, and also 6.3 and 6.5 on confidentiality and disclosure. Now, obviously, in terms of the latter, there isn't confidentiality and disclosure in this process because, of course, I, as the one lawyer, will be giving my advice to both of them at the same time. They will be fully disclosing everything to each other, as they should. Let's move on to other SRA principles that can be applied. Okay, well, we've got to act with integrity. Well, of course, we do that, don't we? We do that in a relatively neutral way, I hope. And I think lawyers are getting into trouble at the moment because they're not doing that. And I need to be careful what I say here, but you know, the NDAs that were drafted in light of the Me Too movement have been shown to hide sexual predators. The Post Office Horizon case is just out there, and we'll see what happens. But we need to be careful that we are independent and we are not working too much for one person. Even when we're working for the couple separately, we have to remain unemotional about it. Although some letters that I've seen would belie that idea. We have to act in the interests of each client. And normally that's easy, isn't it? We're just working for one person. We have to provide proper standard of service to our clients, which we hope we do. And we behave in a way that maintains the trust of the public and in the provision of legal services. Now, obviously, they are very broadly drawn, aren't they? And open to interpretation. But I do think one has to carry oneself in a certain way as a solicitor or a lawyer. And I think they're really helpful in setting out how we should behave. But what happens with the one lawyer service then? What's the one lawyer doing? That is different. Well, instead of acting for each individual person, kind of act like this and kind of perhaps creating some conflict, what I'm doing when I'm acting for the couple is I'm acting in their joint best interests. So I'm advising on that basis. So what does that mean? I mean, that's quite difficult, isn't it? Especially if you're used to working just for one client. So I'm thinking holistically about the whole family. But of course, it must be within the confines of what a court might do. So all of these processes that are not in the court have to have a mind to what a judge might do, what a court would do, what is the practice, what's the procedure, what's the case law. So it's not stepping outside of that. And sometimes, of course, I will need to be saying to couples, actually, I don't think this is in your best interests, this idea you have. Because what generally happens is couples come to me, they already have had advanced discussions about what they think would be a fair settlement. Now, talking about finances, I haven't had to deal with any children work at the moment, because frankly, if people are able to have these discussions, the chances are they've sorted out the children. They generally are not using me in that way, but they might do. And therefore they're fairly advanced individuals, and I'll come on to who the best kind of clients are for this process. But so it's I would say it's a very light touch process. So I'm not mediating, you know, I'm not getting down and dirty in the nitty-gritty of things with them, because I can't, remember, because of the conflict rules. If they are becoming too if they really can't work with me in this very light way, it's not appropriate, and I'm sending them off to mediation, or hopefully I've caught it early on, and we'll come to that then it's just not appropriate. I would say that, although it's not mediation, I would say, hand on heart, I think it's would be good if you had some mediation skills, if you had trained as a mediator or as a collaborative practitioner. I'll come on to that. But again, I'll make this point, and I can't emphasize this enough. The couple must be able to talk to each other outside of our meetings to progress things on their own. Because I have to have a very, I can't emphasize this enough, simply because clients, as soon as one has an interest that's vastly different to the other one, aren't they in a position of conflict, and aren't I therefore acting outside of the realm of being a solicitor? And I must be really, really, really careful of that. Hopefully, I have lots of questions for me. I can't see them at the moment, but I'll come to them. There's plenty of time to get to go through this with you. So what's the lawyer doing? I'm guiding and facilitating. I'm not negotiating. I'm not mediating. So I'm proposing ways forward that I think would be acceptable to the court. I've got to be creative, and of course I have to have a good understanding of the law and its practice. So to give you an example, very early doors, a couple came. Let me give you this example. I mean, it doesn't have to be a real couple, does it? Let's just say it's not a real couple. They had a property together. They had some savings, and they felt very, very strongly. No children, short marriage. They felt very, very strongly that they were just going to divide the equity in the house, and that in this case, the wife was going to keep the savings. They earned broadly the same. All of the assets had been accrued during the marriage, and I had to say, well, I'm sorry, it won't be appropriate for the wife to keep the savings. So they took my advice and shared everything equally, and we got a court order on that basis. So you're dealing with, so they had to go and have those discussions on their own. So it's not, I'm not negotiating. I'm saying I don't think the court would find it acceptable that one of you is getting a lot more than the other for no good reason. All right. So that's quite difficult work, because they really feel that they've done a lot of work on their own. And then suddenly I'm coming along and saying, no, that's not going to wash. All right. So again, it might not be possible. So for them to have this common interest. And remember, they may not have that. They may have been through some difficult times, and they really can't see that they have anything to work for. I mean, I would say that all couples have a common interest in sorting things out. I think you can say that. I think that would be good work. But you'll know you're doing court work all the time, and I imagine it doesn't really feel like that very much to you or to them. But I think most of the skill comes in working out when a case is suitable and when it's not. And I've learned lots of lessons in relation to this. Well, when else is there? Yeah, and also if they have children, isn't it in their common interest to sort things out so that they can get on with parenting and frankly get on with the rest of their lives? So you'll probably know that various models have emerged in the market that have all been given different names, branding and processes, mainly because, of course, no one was telling us otherwise. I think the first one that you would have heard of was probably the divorce surgery, and that's a couple of barristers set this up, feeling rightly that they weren't breaking any rules. And then other solicitors and Solicitors Withers, I think, was the first solicitors to do something like this. They have a model where they have a mediator with them. All family law in partnership have a family consultant with them, and I'll talk about that. And Resolution, who you all, I'm sure, know, is the membership organisation for family law professionals, about most of them whom are solicitors. Obviously they have barristers and paralegals as well, and they created a model called Resolution Together, which I think has really given us more confidence. If you're not members of Resolution, I think joining them to obtain the suite of documents that they've prepared is worth the money. I spent many hours drafting my own retainer and agreement for my clients. I felt I could do that mainly because I'd been on Resolutions DR committee, and I'd also been a member of the Law Society Family Law committee. So I'd been around when these discussions have been had, and I felt able to draft my own documents. But it was, let me tell you, really, really difficult work. I was obviously supremely stressed about it because I felt I was a kind of leader in the field, and I didn't want to get it wrong, and I certainly don't want to be the first person to be sued over it. But one must be very, very clear with the client about what this process is and what it is not. It's absolutely not for everybody. Let me just, I'm going to show you this slide and see if I can, if you can see it. You may not be able to see it. This is my model. I think it's going to look a bit fat. Never mind, I'm going to go online in a second and you can see it. But that's the infographic that I prepared, which was really exciting, actually, because I don't know about you, but most of the time we're just plodding on, aren't we? And it was really nice to step outside and do something a little bit creative. So I'm going to do it. Let me see if I can actually go online. Can I go online? I can. Here we go. Whee! And I hope, hopefully you can see this is my website. One solicitor, one couple, that's what I called it. And I tried to explain to the public that actually people don't want to be in conflict. This is the great Cheryl Picard. If you ever get a chance to read any of her work, please do, because she talks about insight and how we as practitioners and how our clients need to have insight into what's going on during the separation. And there's a sort of that the family law system is sort of set up to enable and perhaps even endorse conflict. And the court assumes that people are greedy to overwhelm others' rights. I'd love to hear your view on this. Lawyers are trained to represent and advocate for the individual. They put their side and unwittingly make things worse. It's just a system. It leaves couples defending their own position and often actually attacking each other to do so. And my view is really that's no way to carry on. We need to desperately change things. We know that the divorce laws changed in April last year, which meant that couples can make a joint application for divorce. Actually, I make this point now, it's not in your notes, but it's not possible at the moment for clients. Oh, you can't see this, can you? Never mind, I'll carry on. It's not possible for clients to it's not possible for you as the solicitor or lawyer acting for both of them in the divorce to jointly apply for divorce on the online court portal. That's because when the court portal was being created, it simply did not think that this would ever happen, that we would ever have one solicitor working for the couple. All right, so I don't know if anyone could text me or put in the chat if they can see my screen, what they can see on my screen here. We've got some questions in the chat. Joe, the screen's not moving. All right, I'm going to come out of there if I can. Stop sharing that. Sorry about that, everybody. I just thought that was really exciting that you could see my website, but you can't see it. So never mind. I'm going to go back to my slides. Here we are. Nope, not that one. There. Okay, let me shut that down. All right, moving on. Okay, so let me go back. I'm going to have to stick you on this screen for a minute because I do want to talk a little bit about my process, and my process is this. I talk to the clients on the phone first of all. I insist on speaking to both of them, just literally for 5-10 minutes, just to get a feel of the case. Now, very often, very early on, I realise it's not appropriate. So, for example, just for saying the wife phones up and it turns out that having looked at the domestic abuse section in my book and also having looked at my website, she's actually saying she's not really sure if really she feels a little bit on the back foot with him, that he's always got the answers, that she finds it difficult to make suggestions to him. And then I speak to him and he says, well, I've got all the answers. I know exactly what's going to happen here. And I really think that that's just what we should do. Well, straight away, the alarm bells are going off for me. It's not appropriate, because clearly, although this might fall short of coercive controlling behaviour or domestic abuse, it's certainly a massive power imbalance. And I don't feel that I can empower the weaker party, particularly in this process. I probably could in mediation, and certainly in a traditional way of working, that might be more appropriate, actually, where you're writing letters and protecting the weaker party. So who are the great clients? Look, ideal clients. They've been separated for a while. They've got over their initial unhelpful emotions. They can spend a bit more time with each other. They're able to co-parent pretty successfully. They can have mutual and balanced conversations away from me. And those discussions, they can use the lawyer's ideas and advice safely and without fear. So I've really got to be really, really careful. Again, moving on, who else are there? I'm going to be a bit of a snob and say this. I think people need to be pretty well educated or self-educated. That doesn't mean they've been to university, but they've kept up with things. They're bright. They have I think quite a high IQ. I think this is important because I'm going to be introducing quite complicated legal concepts to them. I mean, not dissimilar to the way we're talking today, although obviously without as much detail. And I'm saying to them, look, this is what the law is here. And this is, I think, how it applies to your case. They've got to be able to take that on board at this difficult time, which is why I think it's very important that things have calmed down emotionally for them, that they are able to deal with use their intellect rather than their emotion. They've got to be pretty mature to do this. And frankly, I would say most people are not suitable for this process. How many cases have I had? I'm doing it a year and a half. I've had 10, not massive amount. And that's just because most people aren't ready. And I've got a whole list coming up for you of who's not suitable. All right. So who's not suitable? Most clients are not suitable. I'm just going to say that now. And I would say don't try and shoehorn them into it just because you fancy trying this out. It will just be very unhappy situation for all of you. Okay, so let's have a little bit more detail about who's not appropriate. Okay, when there's domestic abuse, the feature of their relationship. Okay, so what's domestic abuse? I just want to remind you of this because I think quite often in our work where it's not obvious, and I've been guilty of this myself, I've kind of gone, well, these people seem okay. And I've not really, I've kind of been a bit blasé about it, and that sounds terrible, but I do think, especially like the money involved, and well, all I'm doing is sorting out the money, I don't need to worry about any of that. But actually, this is a massive feature of our society. So what's domestic abuse? Abusive behaviour is defined by the Domestic Abuse Act 2021, physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic, psychological, emotional or other abuse. So that, there is research that domestic abuse is prevalent in the UK and worldwide. So 1 in 4 women experience domestic abuse. That's a meta-analysis of 366 studies involving 2 million women between 2000 and 2018. That's pretty massive. That was a study published in The Lancet in February 2022. And they say also 1 in 6 men may also be in that situation. So you've got to be really alive to it, and particularly coercive control. And I thought that couple I mentioned, I think that might have been going on between them. And if you are not feeling that you really get what coercive control is, I really recommend a book by In Control. It's called In Control, Dangerous Relationships and How They End in Murder by Jane Monckton Smith. They don't all end in murder, obviously. There's various stages that she describes, and many people live for 40 or 50 years in phase one, and it never moves on to murder. But I do think it's invidious, and I don't think we quite realise the extent of it. And therefore, I would be really cautious about introducing this process to a couple in this way, for obvious reasons. If one person's controlling the other, and I am facilitating that is a really big problem professionally, and also for the weaker party in that situation. And I do think we have a massive duty to our clients to try to get to grips with domestic abuse. I'm going on about it a bit because I do think it's massive. So yes, upskill yourself about domestic abuse, especially true for, as I say, I once heard a very senior practitioner say, "Oh, I don't bother with any of that. I do finances." All right, so do think about that. I think it must be front and center, especially in this, if you choose to do this work. Okay, who else is it not suitable for? In terms of clients, I think about your concern. You've got safeguarding concerns. Again, safeguarding because you're trying to protect your clients. You're trying to protect the children. I think if one of the obvious is if one party asks to keep something confidential, a material fact. For example, my new girlfriend's pregnant, but I don't think you should tell my wife about it, for example. That would be, you're out. You can't, either the person discloses all material information, or this process can't continue. And I think if someone is saying something like that to me in this process, I have to be out. I have to say no. This process is no longer suitable because, frankly, if that person was prepared to kind of effectively lie about that, then what else are they lying about? And of course, the new girlfriend being pregnant is material because it will affect, if nothing else, child maintenance. If there's an obvious power imbalance, that's, I say obvious, it's not always obvious, it's mostly not obvious, but if it's really obvious, like that, the chap that said, "Oh yes, I know the answer, and that's what we're going to be doing," then again, not appropriate. All right, so this is something that I've thought about a little bit in terms of, I don't know if any of you've heard of ACE, Adverse Childhood Experiences. Those of you who do any care or any private children will know about this, but these are, if as a child your client, one of those in your client of your couple experienced violence or abuse, neglect as a child, or a family member attempted or died by suicide, or, for example, aspects of their environment that could undermine their sense of safety, stability and bonding, such as growing up in a household with, say, substance abuse or mental health problems, or instability due to parental separation, or household members being in prison. Now, it's very hard for people who have had adverse childhood experiences to use a process like this, because such people find it difficult to attach often, or attach in an inappropriate way to the practitioner, and they need someone on their side. That is what they need. So I think early doors, when you're finding out all about your client in those initial meetings, I do think you need to spend time getting a little bit of background. I think I've made a mistake with not picking that up early on, and I ought to have done, and that's now part of my initial client meeting. And yes, people who've experienced ACE can be okay in the world. They get by, they often do very well, but without therapy, it's hard for them to do this process. And I'm just highlighting that for you. And I'm getting a little bit of a hair, which is why, of course, it's a scandal that we got rid of legal aid, because such people really, really need that extra help. I'm going to come back to my process, actually. In fact, perhaps if we have time in the question section, mainly because I would have shown you on my website, but unfortunately, as you know, you couldn't see it. So again, who else isn't suitable? Okay, well, it's where one or both have a fixed idea of the settlement and will not countenance any new ideas that I introduce. And I can find that out fairly early on, actually. Are they willing? And I would suggest this to you, use that word. If you get a chance to look at Calm by Professor Elizabeth Stokoe, she did lots of work on how we can talk to people so they'll be willing to engage, and the word is willing. Are you willing to listen to what I might have to say to you? Are you willing to think that maybe to countenance that maybe you've kind of been barking up the wrong tree in your discussions together? Again, a repetition really, but if they don't want to carry out full financial disclosure, or there's a hint of non-disclosure, this is difficult because quite often clients who are using this process are very comfortable. They both understand each other's finances. There's no hint at all that they don't understand each other's finances. But from my perspective as the practitioner trying to get them through this, I suppose I am wondering, I mean, at the moment, I'm kind of insisting that they do a full for me, that they do full financial disclosure, that we even do ask questions of each other's full financial disclosure, because I've got to feel confident that they know what they're getting into. You can't make a decision about a fair settlement if you don't have all the information. So I'm being a bit of a stickler about that, I suppose, as time goes on. And I suppose if they email me to say, yeah, we don't want to do full financial disclosure, we just want to show you this spreadsheet, I suppose that might be acceptable. But we'll have to see if any court cases come out of this, exactly how we're supposed to work. I think if they've tried other non-court processes, and I call that mutual working, and they failed, then again, this probably isn't appropriate. So mediation or collaborative process, they haven't managed to make those work. I don't think this is appropriate. I think they're just they're up for a fight, really, and this is all about not fighting. This is all about not having conflict. All right, so what other things might stop them being appropriate? It's just changing slide for you. Again, if you get an idea that they might be abusing alcohol, drugs, if there are any mental health difficulties or incapacity, I think, again, no. They really need to be at the top of their game, I think. If there's any language barriers and a suitable interpreter is not available, I mean, I think it's really helpful if you speak the language that they do, or that if there is somebody who's not, English isn't their first language, that you have an independent interpreter. Obviously, it must not be a family member who could be skewing what you're saying. Where one or both feel so financially insecure that they can't cope with the upcoming changes, I think that kind of terror, that kind of financial insecurity, again, not great for this process. Obviously, most of the people who are coming to see me have got plenty of money, so it's not a big deal. But even very, very rich people do have that insecurity, and some of them made a lot of money because of that financial insecurity. So again, may not be appropriate because they may always be feeling they could have done better. And if they feel that, really, they need to go and be independent, have to go somewhere independent. Again, I repeat this, and this is worth repeating because I think this is the third time I've said it. If they can't engage with each other without you, no, Again, they really must be able to do that. And also if they have a lack of respect for each other, I mean, if they say things like, oh, she would, if they're very negative about the other one, again, I don't think it's appropriate, because this is all about mutual respect. This is all about good faith. This is all about trying to get to something mutually beneficial. So it's jointly helpful. If it's not, again, you must say no. And these, again, you're picking these things up, hopefully, perhaps even as early as your initial phone call. And I would say that's why the onboarding, I call them onboarding, the individual meetings, the initial calls are vital. Get to know your clients. I mean, that is an SRA thing, isn't it? If you don't do anything else, really understand your clients, really understand where they're coming from. I mean, I don't get any financial benefit out of this, but I use this called, I don't know if you can see that, Our Family in Two Homes. And in here, it's literally a workbook, a physical workbook, where the clients tell you all about themselves. They tell you all about, I buy these, by the way, I pay someone, it's come from Canada. I'm the only person with a license in this country at the moment. But it really helps them think about how they communicate as a couple. How do they make decisions? What's the trust like between them? Things like boundaries, accountability, honesty, generosity, reliability, privacy, judgmental stuff. I ask them to think about their values. What are their core values? In fact, I would ask all of you to think about your own core values. Because if you're the kind of person who really wants to win for your client, this isn't for you, because you're trying to win for both of them. It's quite a different mindset. Also think about the work, but also ask them to think about their decision-making processes and how they come up with decisions. And then it's got all sorts of stuff about how do they communicate their conflict. I know you haven't got this in front of you, but the reason why I'm telling you, why I'm bringing in the workbook, is because I think it's very difficult to do this work on your own. I do think you need the extra help that you might get from the workbook and or from working with a family consultant, and I'll come on to this. But you've really got to spend that time with your clients. You've really got to adopt a relational approach with them, listening to them, all the things that you might learn as a collaborative lawyer or as a mediator. All of those skills you desperately need if you're going to really get to know your client. And the workbook really helps me. And I think also, I mean, this is an interesting point, and it might be why some of your firms won't want you to do this work, is because if you start the process and it turns out it's the wrong one, you can't suddenly then say, oh, well, now I can act for one of you as your lawyer. I simply, because you simply know too much. I think you're out. If you think they are not appropriate as a couple, then you are not appropriate in any capacity. I would say also you can't be their mediator. I don't think anyone from your firm can step in either, because no matter how good your firewall is, your ethical wall, I still think there's possibly a conflict for you to continue to act. So again, that's a difficult one. I think that might be, and that's a judgment call. But my experience is that if you keep going with something, keep going with this process, when it has become unsuitable, it's uncomfortable. It's very uncomfortable for all of you. All right. So, and this is the question, really, I think you've got to ask yourself, are you suitable? Again, I'm going to say it again, I do think some experience training, so I'm just going to have some coffee, in mutual working would be helpful, collaborative or mediation. I mean, even if you have a lot of experience in four-way meetings, I think that might also be helpful. But just working with couples in general, most practitioners are not used to it. For example, can you open a file with 2 people in it? I mean, that's an obvious point. But you may not have, excuse me, you may not have the actual back office functions to do this work. So it's worth thinking about. And this is, again, a help. I think you will need help doing this process. The workbooks, again, help me get to know my client. They help my clients get to know themselves. And who else might help you? I mean, I don't know if you have links with family consultants. What is a family consultant? A family consultant is somebody who is trained. Often they have a therapy background, but they don't offer therapy to clients working in this process. What they offer clients is helpful guidance to help them get them through, really, to kind of deal with any negative emotions that they're having. And it might well be that when you've got to know your client a little bit in your early phone call, or in after the first meeting you have with them on their own, that you say, I think you would benefit from working with a family consultant or even a couples therapist, to just go away and sort out some of that stuff until you come back to me. I mean, I would say that most couples would benefit from slowing things down a little bit. I think as a profession, we're a bit too quick to start things off from a legal perspective. Oh, yes, I'll write that letter for you. And then before we know it, everything's got an awful lot worse. It might be better to say, look, there's no pressing need to do any legal work. There's no pressing need for me to protect an asset or protect a person. If there's no legal need for us to be involved, I would say send all couples away. Just go and work with a family consultant, or even go and work with a couples therapist, just to take the temperature out, rejig your relationship so you can start being more cooperative if they're parents, so they can co-parent better. But also, how will they be as a separated couple? Knowing that the relationship's over, they can go off and do that work. I mean, I would say it's essential, really, that they get that help. Who else might be helpful to you? Well, let's just say I'm working with a couple, and I say I really think this might be one of the ways of looking at this. These are your options in terms of, say, a financial settlement. I think, broadly speaking, this might be a good way of looking at things. And both of them disagree with you. You can hop out of this process and say, look, I'm going to therefore invite an early neutral evaluator to come and talk to you in our session. They'll have all the information that I have, and then they will tell you what they think you might do. I think early neutral evaluation, if you don't know what that is very much like a private FDR, although less formal. So you have your FDR at court, and this is an early neutral evaluation from someone else. I suppose the way I might see it, in some ways I'm the expert, or I should be the expert, but obviously if my clients don't agree with me, or that's causing some conflict, or even if I'm not sure, I'm good, but maybe I'm not brilliant. Also, it may be that I might see myself as a GP if it's a medical setting, and I might want to bring in a consultant to get more specialist help, especially on some things that are tricky and also very triggering. So one such thing might be an inheritance that's been received. Sorry, Celia, somebody just said, Celia's just said that her chat is not working, but I can see your chat, so please do just go in the question and answers. I don't know if the chat's working. I can see your chats, by the way. You told me that the screen wasn't moving, so I would say the chat is working, and so is the Q&A. And Malik's raised his hand. Malik, if you put your question in, if best you can, I'll come to you. So and sometimes it's I need someone else to come in and give their view. I'm going to come back to that in a second. And again, arbitration. I don't think we should feel shy about. I'm not too shy about asking an arbitrator to perhaps make an award. So perhaps the couple have come up with absolutely everything. They've sorted out the capital, the pensions, of course. They've sorted out perhaps child maintenance, and they're just arguing about, say, spousal maintenance. Perhaps it's quantum and duration, which is a very common thing for us to not be able to sort out very easily for our clients. It might be that another view is the thing that tips them into a solution in early neutral evaluation, or an arbitration where the arbitrator actually makes a binding award. I've not tried that yet, but it might be interesting to see what Gemma thinks when she comes to do her section. I think we've got to try to keep people out of court. That's my view. That's why I wrote the book. Really, court is such a disaster for people at the moment that really we've got to do everything we can to keep them out. Okay, I've got a little bit more detail about early neutral evaluation. Again, it is it's worth. I think one of you was going to ask me a question about this, but essentially they give an indication to allow you to have confidence, to allow me to have confidence as the one lawyer that what I said was the right thing to say. And it can just be on paper. Again, it's privileged without prejudice. And our work together, of course, in the one lawyer process is privileged. In fact, it might be a good time for me to talk about that. I mean, the couple agree that our work together is just for us three, or any of these other people that we invite in. And if they do, and I need to make it clear, and I do make it clear that they are free to get their own independent legal advice at any time. They must not feel that I'm the only person giving the advice. The only thing they can't do without the other person's permission is to, let me say, so let's just say I think in this example, I think in this instance we probably wouldn't move far away from X or Y. Then they can't get advice on my legal advice. They agree in my retainer anyway that they won't get advice on my legal advice. Although, I mean, frankly, I'm not that bothered if they do, but that's the agreement. If we all have to agree that they're allowed to do that. But otherwise, everything's just between the three of us. All right. I mean, I've got some questions now, which hopefully there's some questions. I'm going to stop sharing because it might be. Let's see, there's some things in the chat. Okay, so a question from, what percentage of potential clients who approach you are actually suitable for the process? Yeah, good question. I would say a fraction. I would say not a fraction, quite a large fraction, because they've read all about it on my website. In fact, what I might do is you can have a look for yourself. What they've done is they've done quite a lot of research. So they're sort of self-selecting. So they kind of jumped over the hurdle of, oh, yes, I think we might be suitable for this process. So I will definitely hear them out. But I might say, actually, I think that there's too much going on here. I think really mediation's better. In which case I'm a mediator as well, so I can do that. So the following question, because if it's inappropriate for commercial reasons, what is the demand? I found this talk question. I will be buying the book. Thank you for buying the book, Constance. I do think that I think the point is that I have to be quite strict about it. I have to use, I don't know if you do this, but I have a sort of intuition about what someone's like. Will I get on with this person? Will I be able to work with this person? Will this person take on board what I'm saying? Is this person likely to be able to talk to their partner in a reasonable, non-threatening way? It might not be commercially viable for those of you who don't do any other kind of mutual working. So, for example, I might say, I don't think this is appropriate for. So, for example, I did have a case where they both thought one of them thought the one lawyer might be appropriate, but actually, after speaking to him, it was clear to me that actually the collaborative process would work really well. They'd already done the collaborative process. They were just wanting to vary some spousal maintenance. So quite quickly, we sorted things out collaboratively. So I worked with another lawyer collaboratively, working with the other lawyer, not against the other lawyer. And it turned out to work very well. Although initially they wanted to do the one lawyer process. So I suppose I'm attracting the kind of client who doesn't want the traditional approach. They don't want a letter writing service. They don't want to go for their ultimate thing to go to court. I mean, I think all of you, and I hope after you've listened to the arbitration talk later, will have arbitration on your mind all the time, because I think at the moment, quite often people are not having it in their mind at all. Oh, I'm just going to issue my case at court. Oh, it suits my client not to do anything at all. I'm just going to sit here and wait for the other person to issue. But the truth is, your clients will be spending a lot of money on and not getting very far, and your clients will end up not being very happy with you. And that's what we want to avoid. I'm at, in fact, I was supposed to, so I wondered, would it be helpful for me to go through the kinds of thing? Any other questions? Because I could go through, oh, here we are, I've got some messages. Right, if the one party is not coming forward with financial disclosure regarding property abroad, what tactics should the lawyer use to get this information? I think the tactic that the one lawyer has to use is to leave the process, because if there's no financial disclosure, this cannot work. This is the extreme of good faith. It's the extreme of doing everything nicely. That's what this process is, because it's not really possible, I don't think, for the one lawyer to be forensically checking things in such a way. I suppose you all know how you do that ordinarily. I can't answer that question because I don't work in that way. I'm not doing, all of the clients I work with want to do it in an open and good faith way. So if they're not doing that, then I'm out. And frankly, they're coming to see you, probably one of you, to work in a different way. That's not my skill set. And I would be saying to them, I'm out. As simple as that. Hi, Sarah, did you want to come on?
No, hello. Sorry, a bit premature.
Not at all. If you want to ask a question, go ahead. But yeah, I mean, I don't think I can. I think really getting to know your client, and I think that was. I think you picked up on something I said in my talk, which was, one person says, "Oh, don't let the other person know about X or Y." And then I'm saying, well, no, well then you can't use this process, and I don't have the kind of practice where I'm working for people like that. I'm not working for people who are making life difficult. If I get an inkling that they're making life difficult, I have to say I'm out. A bit like on the Dragon's Den. That's why I say it like that. I don't really watch it. Oh, as Gemma says, it sounds wonderful. Yeah, it is wonderful. My way of working is good for my mental health. And we don't talk about that enough really in our business. It's very hard work working for clients who have broken up. Whether we like, this is not part of my talk, but we are like sponges. We are human beings. Our clients have suffered or are suffering. We feel that, vicariously. It's impossible as a human being not to feel what they're feeling. So their anger, their sadness, their hatred, their disbelief, their sadness, their depression, we're sucking it up. There's a reason why I'm big. We all perhaps have our coping mechanisms, and they're not always all that helpful, the way we cope. So I've opted out, and there you are. The rest of you can carry on with that work if you like, but I don't want to. But I'm hoping to use your expertise in different ways, possibly with Gemma Lindfield with her arbitration, perhaps with the other barristers and senior solicitors, perhaps as early neutral evaluators, helping me help those clients. Because I think, you know, the court is we're being recorded, so I'm not going to say the swear word I have in mind, but it's a disaster. You know, in fact, somebody in Surrey was saying to me, in Surrey at the moment, it used to be, you know, maybe 12 months to conclude matters, but now she's saying it's 3 or 4 years, you know, and that's a sort of new normal, which I don't think is going away. I don't think it doesn't seem to be any great compulsion. No, you know, governments of every hue not invested in the court process. They've not invested in the courts. You will be feeling that every day. So if you can upskill out of the traditional way, if you can become go to arbitration, even if you're working for the party who's tactically is better to do nothing, I would say that's not helping you. It's not helping your client. And I think eventually someone's going to bring a case under Part 3 that you have not properly tried non-court processes, that you have not bothered. And I think if someone brings that case, you may find yourself paying back all of your legal fees and paying back, and that your client will have to pay the other person's costs. And I really think that's coming. I think it's actually probably here. I mean, you heard District Judge Wildblood saying, "Do not bring your silliness to me," really, and that's what he was saying about Children Act proceedings. You know, no. You know, go to arbitration if they really can't sort something out. I don't want to. I love arbitration, by the way. So hopefully you will too. But this one lawyer process is a little bit like, it's not for everybody. It's difficult work. I think it's mainly because you have to spend a lot of time with clients, getting to know them. Are they suitable? Can you trust them to behave themselves? Can you? Because remember, I don't want to be the first case brought to the court because someone was not happy. They felt they had a conflict that I didn't adequately deal with, that I wasn't able to give them joint best interests advice, and that somehow things have gone awry. So be really cautious. It may well not be commercially viable if you don't have other ways of working where you can keep them. But if you go too far with the process, I think probably after the first meeting, it's not suitable. I think you shouldn't carry on. I think ethically, you know too much about the other person to act for one of them. You've probably started giving your view about the case already, which means you can't be a mediator. And certainly because you've spoken to both of them, I think that counts you out of being a traditional solicitor or lawyer and starting to just act for one of them. So it is a hot potato. I found it very, very hard work initially. I found it super stressful. But now I'm a year and a half in. Resolution Together exists, so I feel on more firm ground. I feel I've upped my game with the domestic abuse and trying to make sure I'm not facilitating any kind of abuse in this process. And it's been quite a learning curve, and I would say it's not for the faint-hearted. I would say you might want to give it a wide berth, or if you want to do something different, yeah, give it a go. And if you can, keep people out of court. Richard, I think I'm there with that, with no other questions, unless you've got some for me.
Well, I'm very impressed, Joe, because you've ended bang on time at 11:05. I was just about to have my ugly mug back on screen, but you just beat me to it. And that was a really fascinating talk. And you excited a lot of interest from the audience. Fortunately, our chat box and our Q&A box is up and running, and questions have been coming in. So, Joe, thank you very much again for such a fascinating talk. And I'm sure that some of the participants today will be seriously thinking about getting into this branch of the law. So, everybody, we now have a tea break from 11:05 till 20 past. So I hope that's long enough for everybody to have tea and biscuits. And we'll see you back then at 20 past. So bye-bye for now. I was taking too long with my tea break, and sorry to have kept you waiting. And we come to our next speaker, Sarah Corns. And thank you for arriving on time, unlike me, Sarah. So you're a partner with the International Family Law Group. And so that sounds quite grand. And you're going to be talking about, well, the money, I suppose.
Indeed.
Anyway, we can read all about you in the introduction to your talk. I'd better not delay any further. So just to remind everybody, we've got the chat box and the Q&A box up and running. So if you have any queries, please do type in a question or indeed a comment, and Sarah will endeavour to answer that either in the course of her talk, or if you can maybe save a few minutes at the end, Sarah, to answer any questions that you haven't dealt with during the talk. So over to you. Thank you.
Thank you very much, Richard, and apologies to Jo for popping up during her talk. It's really good to be with everybody this morning. If I can just share my screen. Okay, so we should be now on my slides. The purpose of this morning, my talk is to go through several developments in key areas of the law relating to finance in the last 18 months. The focus will be on practical guidance derived from the case law. The topics to be covered are on your screen: division of capital on divorce, special contribution and compensation, agreements, valuations, disclosure, conduct and practical miscellaneous judgments. So first off, division of capital on divorce and the very significant case of WC and HC 2022. This is a really helpful case that summarises the current law in respect of a division of assets on divorce, and considers the interplay between marital and non-marital assets and how this impacts needs and sharing. It is a case that can helpfully be explained to clients as a summary of the law. The facts of the case: the parties were married for 15 years and had 2 children who required frequent medical care. The husband came from a wealthy family who owned a significant stake in a publicly quoted company. The parties had entered into a prenuptial agreement followed by a supplemental agreement intended to protect the resources received or anticipated to be received by the husband from his wealthy father. And indeed, the parties' lifestyle during the marriage was largely funded by the generosity of his father. So the parties entered into a post-nuptial agreement, although the wife declined to sign the agreement, the agreement provided for the wife to receive around 7.1 million plus child provision. The husband submitted that it was a binding agreement which had been reached after informed negotiations between the parties and their legal representatives. The wife made a financial remedy application seeking an award of 10.5 million. The husband's main argument was that his father's gifts had ceased. However, a year before the parties separated, the husband's father transferred assets worth 23 million euros into a trust of which the father was the principal beneficiary and the husband a discretionary beneficiary. So the month after the wife's petition was served, the assets were transferred out of the trust and back to the father pursuant to an instrument of partial revocation. It was held that the wife's award was 7.45 million net, and the husband would make a very high level of financial provision for the children. So the award went beyond that set out in the post-marital agreement in order to meet the wife's needs, obviously with reference to the standard of living of the parties, which is a matter that we will come on to. So the practical guidance and key points of this case, Mr. Justice Peel gave the leading judgment, and he very helpfully summarised the law on divorce as follows. One, as a matter of practice, the court will usually embark on a two-stage exercise. Firstly, computation of assets, and secondly, distribution, Sharman and Sharman. Two, the objective of the court is to achieve an outcome which ought to be as fair as possible in all the circumstances, Lord Nichols in White and White. Three, there is no place for discrimination between husband and wife and their respective roles, again, White and White. In an evaluation of fairness, the court is required to have regard to the Section 25 criteria, the first consideration being given to any child of the family. Section 25A is a powerful encouragement towards a clean break. Baroness Hale in Miller and McFarlane and McFarlane. And three essential principles at play are need, compensation and sharing, again Miller and McFarlane. In practice, compensation is a very rare creature indeed, and we will be talking about compensation later in the talk. Where the result suggested by the needs principle is an award greater than the result suggested by the sharing principle, the former shall prevail, Sharman and Sharman. In the vast majority of cases, the inquiry will begin and end with the party's needs. It is only in those cases where there is a surplus of assets over needs that the sharing principle is engaged. Pursuant to the sharing principle, the parties are ordinarily entitled to equal division of the marital assets, and excuse me, non-marital assets are ordinarily to be retained by the party to whom they belong, absent any good reason to the contrary. Scatcliffe and Scatcliffe, that's 2016. Excuse me a moment. In practice, needs will generally be the only justification for a spouse pursuing a claim against non-marital assets. It was pointed out by Lord Justice Wilson in KVL that there was at that time no reported case in which the applicant had secured an award against non-matrimonial assets in excess of her needs. The evaluation by the court of the demarcation between marital and non-marital assets must be carried out with a degree of particularity or generality appropriate in each case, heart and heart. Non-marital assets, non-marital wealth has one or more of three origins: property brought into the marriage by one or other party, property generated by one or other party after separation, for example, significant earnings, and inheritances or gifts received by one or other party. Sometimes difficult questions can arise as to whether and to what extent property which starts out as non-marital acquires a marital character, requiring it to be divided under the sharing principle. This all depends on the circumstances, and the court We'll look at whether when the property was acquired, how it has been used, whether it's been mingled, or as we sometimes say, intermingled with the family finances, and what the intention of the parties were. So needs are an elastic concept. I think there's a numbering, it should be paragraph number 11 and not 12 on the slide. But needs are an elastic concept. They can't be looked at in isolation. Sharman and Sharman. The Family Justice Council, in its guidance on financial needs, and this is guidance to the judiciary, in 2018, stated that it's in an appropriate case, typically a long marriage, subject to sufficient financial resources being available, courts have taken the view that the lifestyle, i.e. the standard of living the couple had together, should be reflected as far as possible in the sort of level of income and housing each should have as a single person afterwards. So too, it is generally accepted that it is not appropriate for the divorce to entail a sudden dramatic disparity in the parties' lifestyles. I mean, of course, in practice, we all know that many divorcing couples are creating two homes out of one. So there is often inevitably some reduction in the standard of living. In Miller and Macfarlane, Baroness Hale referred to setting needs at a level as close as possible to the standard of living which they enjoyed during the marriage. A number of other cases have endorsed the utility of setting the standard of living as a benchmark which is relevant to the assessment of needs. But standard of living is not an immutable guide, and each case is, of course, fact specific. Mr. Justice Peel adds that the source of wealth is also relevant to needs. If it is substantially non-marital, then he says, in my judgment, it would be unfair not to weigh that factor in the balance. So coming on now to the case of VV and VV 2022, which considers the relevance of premarital cohabitation and how this links to the sharing principle. The facts of the case are that the parties met on the Eurostar. The wife was a music composer living in London, and the husband had a career in the software industry in the USA. It was a very short marriage of less than 5 months prior to the parties separating. The husband was living in the US and started working with AB Company. In September 2019, an agreement was reached between the husband and AB Company that the husband would leave. In October 2019, there was a settlement agreement whereby the husband was entitled to acquire 700,000 units upon the startup listing. In November 2019, his employment with AB Company formally came to an end. The parties married in January 2020 and separated in June that year. So it was wife's case that they started living together in November 2018. Husband said it was December 2019, and thus his employment predated cohabitation. During the period of cohabitation, the wife claimed, he was working at AB Company and he was earning the right to acquire the units in the startup. And so those units had become matrimonial in nature, and therefore she had a sharing claim. In his Form E, the husband stated that the units were of nil value, being illiquid and speculative, and he later took steps to pre-sell his rights. At the same time, the wife was in communication with the founder of the company to prevent him releasing the units. The husband pre-sold $11.5 million of units, which he didn't disclose to the wife or to the court. Mr. Justice Peel was satisfied that cohabitation had not started until December 2019, after the husband had finished working at AB Company and he had left the USA for good. The parties moved into a shared rented property in London together. He said until then, they had been in a committed relationship where they spent time together, were supportive and affectionate, and shared dreams and ideas, but which fell short of cohabitation, equating to marital norms. He goes on to say, in my view, engagement may be an indicator of the strength of the commitment and shared life, and may be an evidential factor pointing towards a period of cohabitation. It should not ordinarily be seen as a separate event, which by itself gives rise to sharing entitlement. And because the husband's assets were acquired before December 2019, the wife was not entitled to share, and thus her claim was confined to her needs. So practical guidance from that case: cohabitation does not properly begin until the parties move in together on a full-time basis. An approximate period of 45% of the year spent living together doesn't constitute cohabitation. A partnership will simply be regarded as a committed relationship in such circumstances. And a lengthy engagement between a couple is not likely to justify an entitlement to the sharing principle if there are no other indicators of cohabitation. And again, each case will be fact specific. So coming now to special contribution and compensation. TM and KM 2022. This case looks at the principles of compensation and where it might be appropriate. So in this case, the wife was a high earner and successful. She had a successful career in investment finance before ceasing work in 2008. She made relationship-generated sacrifices by moving to London to be with her husband and provide childcare. She also moved to the Middle East in 2010 and 2016 to support the husband's career. He had a highly successful career in investment banking, and in recent years his income was around $2 million. His Honour Judge Hess considered the earning capacity of both the parties and also future earning capacity, including any reasonable expectation that that capacity may increase. One of the issues for the case was whether the wife should be compensated for the relationship-generated sacrifices that she made and in turn impacted on her own future ability to earn. In this case, there was no basis for additional provision for the wife on a needs basis, and therefore she sought a compensation claim. His Honour Judge Hess, having first determined that her sharing claim was greater than her needs claim, added a total of $500,000, which was to be paid in 5 tranches, to her award on a lump sum clean break basis, resulting in a total lump sum payment to her of just over $2.5 million. And this was to ensure that a fair outcome was achieved. The additional $500,000 was a discrete compensation payment for the relationship-generated sacrifice that she had made as a potentially high earner. And it was said that it was unlikely that she would be able to earn anything like that she would have been had she not made that sacrifice. And in making this award, His Honour Judge Hess took a similar route to Mr. Justice Moore in RC and VC who had made a compensation award of £400,000. So practical guidance, it remains rare for compensation to be awarded in a case, and it will always be fact specific. And a case will need to be truly exceptional for there to be a discrete compensation award made. When quantifying a compensation claim, the court must consider the statutory steer in favour of a clean break arising from Section 25 AMCA. So the next case to consider is SS and RS, and that's 2023. This case illustrates a failed attempt to claim compensation. The husband applied for £80,000 compensation for the delay in the wife complying with an undertaking to use her best endeavours to procure his release from the mortgage of the family home following a financial remedy order in March 2019. The wife succeeded in remortgaging the property and releasing the husband from the mortgage in January 2023, and she issued her own application to strike out the husband's application. He said he had proper grounds for compensation arising from the fact that her failure to obtain his release from the mortgage led to him suffering significant financial loss. And also with reference to his status, he claimed as a domestic abuse victim pursuant to Section 1(2)(b) of the Domestic Abuse Act 2021. He claimed that the wife's behaviour was abusive and that he suffered economic abuse as a result of her behaviour. Sir Jonathan Cohen struck out the husband's application for compensation as being without merit. He said, a case in which compensation is awarded is vanishingly rare, unlikely to be confined to the very specific circumstances that arose in McFarlane. I find the use of the word vanishingly rare interesting because it implies that it is going to cease altogether, which isn't the case from the previous case that we have just looked at. So there's no provision for making financial compensation under the Domestic Abuse Act 2021, and the husband was mistaken in trying to extend the principle to include the court having the power to award compensation. And the husband was ordered to pay the wife's costs for not withdrawing his application after he had been informed that he was removed from the mortgage, and thus avoiding the costs of the hearing. And the judge commented that whilst the husband's application was without merit, the period of 1 month that was provided for the wife to release the husband from the mortgage was unwise, and a more realistic time frame should have been given. So the practical point is that practitioners should consider whether the conventional period of 28 days is reasonable when drafting consent orders. I mean, generally it's not, particularly when transfers are subject to mortgage or remortgage. The case of DR and UG 2023. This case sets out the test that needs to be satisfied to succeed in a special contribution argument. So on the facts of this case, the special contribution was not held to be a reason to depart from equality. The husband was CEO and the driving force behind a management buyout of a trading company. The company subsequently sold for 400 million, of which he received 70%, so 280 million. He had argued that as a result of his special contribution, there should be a departure from equality in his favour. The wife's case was that she should receive 50% of the party's assets. And it was held that his argument was rejected and the party's assets were shared equally. So the practical takeaway from that case is the concept of special contribution does still exist and is likely to do so until the Supreme Court says otherwise. But the availability of the concept has been significantly circumscribed over the years. The three-stage test to be satisfied when running this argument remains that set out by the Court of Appeal decision in Work and Gray 2017, and the criteria are: the work must be wholly exceptional in nature, such that it would be obviously inconsistent with the objective of fairness for that work to be ignored. There needs to be such a disparity in the respective contributions of the parties to the welfare of the family that it would be inequitable to disregard it. And thirdly, the amount of wealth alone must be so extraordinary so as to make it easy for the party who generated that wealth to claim an exceptional or individual quality which deserves special treatment. Coming on now to agreements, WC and HC 2022. This case, in addition to summarising the law in respect of how assets are divided on divorce, as we've already seen, it looks at the court's treatment of inheritance. Mr. Justice Peel summarised the law in Radmacher as follows. Firstly, there's no material distinction between an ante-nuptial or prenuptial agreement and a post-nuptial agreement. If the ante-nuptial agreement or indeed a post-nuptial agreement is to carry full weight, it is important that each party should have all the information that is material to his or her decision, and that each party should intend that the agreement should govern the financial consequences of the marriage coming to an end. It's assumed that each party to a properly negotiated agreement is a grown-up and able to look after him or herself. So the first question is whether any of the standard vitiating factors, namely duress, fraud, or misrepresentation, are present. Even though the agreement doesn't have contractual force, these factors will negate any effect the agreement might otherwise have. Unconscionable conduct, such as undue pressure, falling short of duress, will also be likely to eliminate the weight attached to the agreement. And unworthy conduct, such as exploitation of a dominant position to secure an unfair advantage, would reduce or eliminate it. The courts may take into account the party's emotional state and what pressure he or she was under to agree. But that can't be considered in isolation from what would have happened had that party not been under such pressures. So the court should give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications. Unless the circumstances prevailing, it would not be fair to hold the parties to that agreement. And in the present case, although the wife had been placed under stress and pressure and was uncomfortable with the process of entering into the agreements, she had not been under undue pressure to enter into the premarital agreement. She had not signed the premarital agreement, but it was upheld by the judge. And in this case, that notice was given to practitioners that they must abide by court orders and the efficient conduct of financial remedy proceedings. So High Court statements must only contain evidence and not argument or rhetoric. The requirement for the font and spacing of the Section 25 statement had been ignored in this case, with the result that the wife unfairly gained 33% more space for her narrative. And a week before the trial, the wife sought to introduce a 102-page section of narrative comment. One working day before the trial, a husband had produced a financial analysis of the parties' joint accounts. So the judge stressed that documents of this nature must be provided well before the hearing, such as before a PTR or a final directions hearing. Case of SC and TC, which concerns a post-nuptial agreement which was not upheld in circumstances where the husband had voluntarily relinquished his entitlement to a sharing and needs-based award. The facts of this are very specific and quite unusual. The parties had entered into a post-nuptial agreement, and the husband had a shortened life expectancy due to Parkinson's disease. After finding out that the husband had visited a sex worker, the wife asked him to sign the agreement, saying that she would only stay with him in the marriage if he did so. The husband was concerned about being on his own in later years, and he signed the agreement, which gave the wife 80% of the assets. His solicitors had strongly advised him not to enter into the agreement. So within the proceedings, the wife issued a show cause application stating that the agreement was determinative. The husband argued that the agreement carried no weight, although he needed more than 50% of the assets to meet his housing and future needs. He sought equal division of the matrimonial assets. At the time, he lacked litigation capacity and was represented by a litigation friend. And it was held that the agreement was not upheld because of his vulnerability at the time that he signed. And the judge commented that the wife took advantage of his vulnerable situation to gain a substantial financial advantage. And the agreement would also leave the husband in a predicament of real need. He required familiar accommodation and care to ensure, as was his wish, that he didn't have to go into a care home. So practical guidance. Parties should assume that the court will give effect to their agreements as long as the requirements are met, but of course they are not watertight. And parties and lawyers should ensure that they review agreements to ensure that the terms are appropriate in the event of any change in circumstances. Case of HD and WB, that's 2023. This case concerns a prenuptial agreement that was signed on the day of the marriage, and the court had to determine whether the parties should be held to it where there'd been an absence of legal advice. The agreement was signed in 2014 and the parties separated in 2020. The husband had not taken any legal advice on the prenup prior to signing it. The realisable assets exceeded 43 million, held nearly exclusively by the wife. The husband sought to disregard the agreement as it was entered into in undue haste with no legal advice and insufficient disclosure. He said that he didn't fully understand it, and in any event, it didn't meet his needs. and Mr. Justice Peel departed from the terms set out in the P&A, but not owing to lack of legal advice, but because there had been a change in circumstances. In this case, the court considered the Section 25 factors and the financial landscape, which had changed considerably, such that the agreement did not meet his needs fairly. So the husband was provided with 1.9 million, which was 4% of the liquid wealth, plus a housing fund of 2.5 million, subject to the wife's reversionary interests. But he was ordered to pay 120,000 towards the wife's costs. So the absence of legal advice on a P&A is not a vitiating factor. Sound legal advice is desirable, but not essential. And when considering the absence of legal advice, the court should look at all the circumstances, including whether the party had the opportunity to take legal advice and sufficient understanding and meaning of the consequences of the agreement. Coming on now to valuations. The case of AVM 2021 considers various points, including the date used to value assets, sharing beyond separation, and the consequences for failure to negotiate and adding back for disproportionate legal costs. So the husband worked in private equity and the wife was the beneficiary of a valuable trust fund. The parties had properties in several countries. In 2015, the husband founded a private equity fund. In October 2016, he and his business partner established Fund 1, and in October 2018, they established Fund 2. And the husband had expected to more than double the value of the investments. One of the issues for the court to consider was whether the wife had any interests in Funds 1 and Fund 2. It was held that as the marital request was taken at the date of trial, the judge said that the marital carry in each fund was to be shared equally. He did, however, dismiss the wife's assertion that she was entitled to share in carry that the husband generated after the trial date by virtue of her contribution to the family. That was firmly dismissed. The judge decided that the co-investments in both funds would be shared equally. So the marital request in a case is to be calculated at the date of the trial. Mr. Justice Mostyn has said it is normally the right date because the economic features of the parties' marital partnership will have remained alive and entangled up to that point. The fruits of the partnership will have been divided and distributed. Sorry, will have not have been divided and distributed. So the share of one partner in the partnership assets is likely to have been unilaterally traded with by the other. If costs are found to be excessive, then the court will add them back into the asset schedule. And in this case, the wife's costs were found to be excessive at 150,000. As a result, they were notionally added back into the asset schedule. And the wife in this case had also failed to negotiate, and therefore a costs order was made against her. Moving now to the topic of disclosure and X v Y 2022, which considers the consequences of non-disclosure and the court's power to keep open claims, to keep capital claims open, to preserve the possibility of a fair outcome in the future if there has been non-disclosure. So the facts of this case are that the husband had not told the truth in presentation and disclosure. the judge said, "My overall view is that I regard the husband as dishonest and unreliable and should treat everything he told me with a great deal of caution." So in order to persuade the wife to relocate to the UK and give up work, he had dishonestly and falsely manufactured bank statements indicating that the company was to be bought for 80 million. The bank statements actually purported to show a 10% deposit having been paid. The upshot was that the wife was left with virtually no assets in the UK and reliant almost entirely on state benefits, and the husband downplayed his earning ability. So the wife argued that her capital claims should be adjourned in the light of the husband's failure to identify how such claims would be met. And it was ordered that she would receive an extendable 10-year periodical payments term for £5,000 per month for herself and the children from May 2023 to give the husband time to obtain a job within his earning capacity. And I'm going to move on to the next section. The detailed notes are available to you as the lecture notes, which go into further detail than the slides. So moving now to the case of Svetkov and K-Rover 2023, which considers the procedure to be followed where allegations of conduct are pleaded. So there were assets of around 48 million. And the parties were married in 2009, and the marriage ended in September 2020. But there was 5 million in dispute in the proceedings, and costs of 3 million were incurred. So the wife argued for equal division of assets. The husband argued a 60-40 split in his favour because of the wife's conduct. The wife repeatedly lied to the husband and to the court. There were numerous material omissions in her for me and falsehoods about the whereabouts of valuable jewellery, which required freezing orders and search orders. And in her oral evidence, she herself acknowledged her own lies. Jewellery was stored in a safety deposit box in Harrods, but without the husband's knowledge. She persuaded Harrods that the keys had been lost and a new set was cut for her. She took the jewellery, and at a hearing in March 2022, she was asked where the jewellery was, and she said in her villa in Cyprus. The husband's solicitors travelled there to inspect the safe, but there was no jewellery to be found. So Mr. Justice Peel included 6,690,000 for the jewellery, including watches and diamonds, on the wife's asset schedule. The wife had also colluded with the husband's business partner, with whom he had been in a feud, to try and cause inflict damage to the husband. And he claimed that she blocked the sale of a company, which led to financial loss to him. She had handbags valued at over 900,000. At an earlier hearing, she said she only had 20, but 150 handbags were found in her possession. And I always think of this as the handbag case, not that I have handbag envy. So it was held that there was to be an equal division of assets, including those that the wife denied having in her possession. The husband, however, did not succeed on the basis of conduct, and the wife's behaviour was accounted for by way of costs for litigation misconduct. So each party exited the marriage with just over 24 million. And on the topic of anonymity, Mr. Justice Peel identified the parties saying the litigation misconduct of the wife is of the utmost gravity. It is in the public interest to be aware that one party abused the system and repeatedly lied, eating up valuable court time and resources in the process. He also went on to say that I take the view that the public is entitled to know that the husband has not paid a penny of UK tax, nor even filed UK tax returns since his return to this country in 2018, despite the parties being citizens of this country and resident here, having children who are educated here and owning multiple properties here. So the practical guidance is that a party asserting conduct must prove the facts relied upon, and if established that those facts meet the conduct threshold, which has consistently been set at a high or exceptional level, and that there is an identifiable negative financial impact upon the parties, which has been generated by the alleged wrongdoing. So stage one is if the facts relied upon are established, the court will go on to consider how the misconduct and its financial consequences should impact upon the outcome of the financial remedy proceedings, undertaking the Section 25 exercise, which requires balancing of all the relevant factors. And stage two must be followed where there is or may be conduct issues. And I won't go through those for lack of time, but they are in the detailed notes. It was said that the court should determine at the first appointment how to case manage the alleged misconduct. And it is important that it is case managed, it is pleaded and case managed at an early stage. And if the court is satisfied that the exceptional threshold requirement is met, that the court would take into account the proportionality to permit the allegations to proceed. And the court will also take into account whether the allegations, even if proved, would be material to the outcome. And if alleged conduct arises after provision of the Form E, for example, if one party dissipates assets, the parties must plead as soon as possible. Moving on to the matter of costs, Xanthopoulos and Rakshina considers two applications. The husband made an application for a further legal services payment order, and the wife, excuse me, made an application to be released from undertakings pending determination of the husband's claim not to deal with a bank account. So the facts of this case are that the husband had been granted a legal services payment order, but he had overspent. In fact, he had significantly overspent, and his solicitors came off the court record on the day before the hearing. Litigation had already cost the couple over 5 million, with future costs up to 2 million to follow. The total assets in the case were 22 million, and the husband suggested that the wife's corporate assets were worth 30 million. And Mr. Justice Mostyn described the preparation for the hearing as shocking. referring to the bundle limit, breach of the practice direction on bundle limits, and skeleton arguments exceeding 10 pages and being filed late. He said it should be understood that the deliberate flouting of orders, guidance and procedure is a form of forensic cheating and should be treated as such. Advisors should clearly understand that such non-compliance may well be regarded by the court as professional misconduct, leading to a report to their regulatory body. And on the issue of anonymity, he said that transparency should be a starting point, and that the person who seeks to anonymise the judgment must apply to do so. He did, however, direct that the children and their address should be anonymised. Legal services payment orders should only be made in respect of outstanding costs to current solicitors, and a solicitor who ceases to act but has made cost estimates that can no longer be used in the context of those proceedings, and new solicitors should be instructed. The case of PVP 2022. This considers how costs owing by one party to their lawyers at the final hearing should be treated in the sharing exercise if they are materially different. The facts of this case are it was not a big money case, assets of 800 to 900,000, but the total costs were in excess of 150,000, the wife 130,000, and the husband 24,500. All the costs have been paid to the date of hearing from marital funds. So because costs owing are liabilities on the asset schedule, no order as to costs doesn't mean anything, because the other party will still pay those costs either on a needs basis or part of the sharing principle, without any assessment of whether they are reasonable or fairly incurred. So instead, it's appropriate to bring back the amount already paid by each party to meet their legal costs and divide the gross amount to establish the share of the marital partnership resources. I see the time is nearly 1:15, so I am going to just skip the rest of my lecture, but the notes are available, and I would also suggest that you read the notes on Mr. Justice Peel's comments on the financial remedy court, his review of the last year of that court, which is a really interesting review, referring to the increased use of private FDRs and also the single lawyer model. And that's certainly well worth reading. So thank you very much for listening. And if there are any questions that I can assist with, Mr. Malik, I'm having a look. Sorry, I can't see, apologies, I can't see the question. I will stop sharing my slide. That may assist. Apologies, I can't see, There is a question, any case law regarding future earnings and pension contribution? That's Kumandu. Thank you very much for your question. Not that I'm aware of. Thank you for your question on that, and I'm sorry I'm not able to assist with that one. I'm just looking to see if there are any other questions through the chat box. I can't see any further questions.
Well, I think, Sarah, that would be a good time to draw your talk to a close. And you've sparked a lot of interest, and you've had a good few questions there. And thank you very much indeed for a very interesting talk and very relevant to a lot of the people watching.
Thank you very much, and thank you. Goodbye.
Bye-bye now. Well, now, our next speaker, Stuart Barlow, is a very experienced practitioner in the business for 40 years, I believe, Stuart. And
right, yes.
And you've been in a pretty responsible post at the Law Society. Let me just see. Chief Assessor of the Family Law Accreditation Scheme. So that must have given you a lot of interesting experience. And you're still a member of the Children Panel.
Welcome, everybody, to this session on fact-finding hearings in private children matters. And the question is, where are we now? And I'm Stuart Barlow. I've been working in the area of family law for over 40 years. I've conducted most of my private children cases, and including quite a lot of fact-finding hearings. So much of what I have to say today is a reflection of what I've learned over the years. I'm sorry you don't have any slides in front of you, but you've got copies in your notes, and also obviously an extensive set of notes which you can look at later. I'm also mindful of the fact that we're drawing up to lunchtime, so I want to make sure that we don't overrun, because we've got plenty to hear about this afternoon. But in general terms, apparently there were 55,645 private law cases started in 2020, around 2 or 3 years ago. About 40% were thought to involve allegations of domestic abuse. And I understand that the figures are no different today as they were back then. Sadly, statistics are in short supply when it comes to accuracy. But many private children cases proceed through the family courts without too many complications. However, some cases produce challenging issues which confront us perhaps occasionally, and we can find ourselves wondering what to do and how to handle these situations. I think fact-finding hearings fall into this category. Fact-finding hearings arise where there is an unresolved issue of domestic abuse that could impact on whether contact should take place at all. If contact does take place, can arrangements be made to ensure that contact is safe and does take place at least in some form? When dealing with a private law application, and in particular a child arrangements order, the court will make a number of assumptions, and I'd like to explore those with you. Now, this is still the position even when one party makes an allegation of domestic abuse. What are these assumptions? First, the court must make a decision that is in the best interest of that particular child, and that's something no doubt we're all familiar with. The second is the court has a duty to promote contact with the parents in accordance with the child's right to family life under Article 8 of the European Convention on Human Rights. The third assumption is that there is no presumption either way as to whether or not a child should have contact with a domestically abusive parent. Pause there for a moment. Just because he has been abusive doesn't necessarily mean that he can't have contact. The fourth assumption is that the involvement of both parents in the life of the child will further the child's welfare. Now, you may have had experience like me, where if you put that last point to your client, they may not necessarily agree, but that's emboldened in not only statute, but also case law over the years. So both parents need to be involved, if at all possible. Now, these assumptions, of course, are just a starting point and will not apply if the evidence shows that any involvement by the parent will expose the child to a risk of harm. Now, when I see a client, sometimes the client objects to contact, and I first of all say to them, if it's the father they are accusing, mum may say, well, I don't want him to see the child. And the first question I put to them is the child safe in his care? And invariably the answer is yes, in which case I usually say to them in which contact is going to take place. And so, of course, that's a very important point. So the risk issue is, of course, very much a basic point. Now, there isn't a presumption that if domestic abuse is proved or admitted, there should be no contact. But the court does have to look carefully at what the level of risk is, how it can be managed, and what possible advantages and disadvantages of contact might be. So you'll see that the court needs to exercise a balancing act, taking into account all these assumptions. In doing so, the court will have the help of Practice Direction 12J. The full title is Practice Direction 12J, Child Arrangements and Contact Orders, Domestic Abuse and Harm, which sets out the points the court should consider where abuse has happened. Now, these are the effect of the domestic abuse on the child where the child is living, the effect of the domestic abuse on the child in the relationship with the parents, whether the abusive parent is using the process to continue a form of domestic abuse against the other parent. Sometimes it's said that father only wants to see the child in order to get back at the mother. The likely behavior of the abusive parent during contact. And of course, that's really important, isn't it? The capacity of the parents to appreciate the effect of past domestic abuse and its impact on the child. So the court will look at each individual case and see what is appropriate. In each case, the court still has to decide what is in the child's best interest. And that will mean deciding whether contact is safe. In some cases involving domestic abuse, the question for the court is how can contact be made safe? In other cases, the question is whether contact can be made safe at all. When the family court has to make decisions about a child's welfare, the court needs to know or decide what has happened in the past. Where the court has to first make a decision on whether the alleged facts are true or not, a fact-finding hearing should take place before the court makes an order regarding the child in question. Until the court has decided whether the allegations are true, it will work on the basis that they might be true and will put safe arrangements in place. This may mean no contact or supervised contact. So again, looking at it practically, sometimes a father wants to see his children and there is an allegation of domestic abuse. And you then have to present the advice to the client that contact is not going to take place immediately. Or if it is, it's very restricted, maybe indirect contact, or maybe supervised contact. And clients find that hard to take, especially if they deny adamantly any allegations that's been made by the mother. If the court decides that a finding of fact hearing is needed, it will be required to put measures in place to bring this about. A fact-finding hearing is a court hearing that considers the evidence surrounding allegations made by one party against the other. The court needs to make a decision as to whether alleged incidents did or did not happen. Evidence is heard, which will normally include parties being cross-examined. After having heard the evidence, the judge or the lay magistrates will decide on the matter. Most commonly, these allegations concern domestic abuse, but can relate to other aspects of behaviour. Domestic abuse can be included as neglect, emotional and physical harm, and violence. Now, it's for the party making the allegations to prove that they are true. The judge or the lay magistrates will consider, on the balance of probabilities, whether it is more likely than not that the allegations are true. In preparation for a fact-finding hearing, the party making the allegations will be directed to serve a list of the allegations in the form of a Scott schedule. Each incident should be numbered and set out in date order, stating the date of the incident and details of what happened and where, details of any witnesses to the incident, and the involvement of the police and medical services. The person against whom the allegations are made will then be directed to respond to the allegations. The person accused should respond to each allegation in turn, setting out their account of the incident or stating that the allegation is denied. Both parties will also be asked to make a written statement setting out their evidence. Witnesses can also make a statement and give evidence with the court's permission. How does the court decide which cases need a fact-finding hearing? When a private children case comes before the court, the application triggers a process requiring Cafcass to carry out basic safeguarding checks. These reveal whether the family are known to the police or social services, or if the parents have any relevant convictions or pending prosecutions. Cafcass will also attempt to speak to each parent on the telephone before the first court hearing to check whether they believe that there are any safety issues. If a parent thinks that there are safety issues, they should raise these with Cafcass during those allegations. I often say to a client when I know that it's taking this particular course, that during that conversation on the telephone with Cafcass, they should raise it. They mustn't forget, because of course it will impact on what happens later. Cafcass will then write a safeguarding letter setting out details of their inquiries and file this with the court and provide the parties with a copy. Cafcass may recommend that a fact-finding hearing is necessary. Of course, that would be before the application is fully considered by the court. Now, I quite often find that that safeguarding letter is really useful in so many ways, but it sometimes highlights what happens when Cafcass look at it, and they can give the court at least some kind of steer as to whether a fact-finding hearing is relevant. What are the reasons for a fact-finding hearing? The decision about whether to hold a fact-finding hearing is for the court, not Cafcass or the parties. So even if the parties agree that a fact-finding hearing is necessary, it has to be confirmed by way of a court order, and it's the court that has the say. At the first hearing, commonly known as FEDRA, the first hearing and dispute resolution appointment, the court has to decide Practice Direction 12J, which informs the court how it should approach cases involving allegations of domestic abuse. The thrust of Practice Direction 12J is that if disputed allegations would be potentially relevant to the final decision of the court should determine the dispute by deciding whether the allegations are true or not. The decision about whether or not to hold a fact-finding hearing should be taken early in the proceedings. And so it's something that you should raise or could be raised at the federal hearing, and often is highlighted by Cafcass in their safeguarding letter. The practice direction sets out the procedural framework to be followed. It sets out factors to be taken into account when determining whether to make a child arrangements order where domestic abuse has occurred. When deciding the issue of child arrangements, the court should ensure that any order for contact will not expose the child to an unmanageable risk of harm. The court is required in its judgment or reasons always to make clear how its findings on the issue of domestic abuse have influenced its decision on the issue of arrangements for the child. Practice Direction 12J can be downloaded in full from the internet, and I would recommend that you read that. And frankly, I read it occasionally just to simply remind myself when I'm going to court as to what the court should take into account, because it does vary. If you're before lay magistrates, they may not necessarily be advised by the legal advisor on all the issues that you consider to be important. If a party has been directed or to respond to a Scott schedule, a template form can be used. And again, that's easily available, and it means that you don't need to start from scratch. I've already set out details of what this contains and the style, but I would make particular mention of the role of the judge or the lay magistrates. They will hear evidence and decide whether they find each allegation to be true. If the judge finds that an allegation is true, he or she will state that the allegation is found. If the judge decides that the allegation is not true, the judge will state that the allegation is not found. If the judge cannot decide whether the allegation is true or not, the judge may state that the allegation cannot be determined either way. Each party must prepare a witness statement in advance of the hearing. Usually the person making the allegations goes first. Each allegation or incident will be dealt with by the parties in their statement. Sometimes the court will place a limit on the number of allegations that should be included in the schedule. This is to ensure that the case is manageable and the fact-finding hearing is focused on the most relevant and perhaps more serious issues. It's not uncommon for a victim to set out a long list of allegations, so the court will need to go through what I'd describe as a pruning exercise by asking the parties to reduce the list to say 5 or 6 of the more serious allegations. So that's something that you may need to prepare your client for, because in their mind, every single allegation that they come up with is important. It is to them, but of course the court may say that it's important that we focus on perhaps just a small number rather than a long list of them. What happens at the fact-finding hearing itself? Well, the person making the allegations of abuse and any witnesses will give evidence first. The accusing party will confirm or indeed correct their witness statement and may then be asked questions by the other party. Sometimes the judge will ask some questions. The same process takes place for the person who is accused of the abuse and any witnesses he or she is brought to court. The parties will then be able to make submissions to the judge or the lay magistrates. The judge will then announce the decision and give reasons. This process might be adapted if one or both parties has no lawyer, and the court makes special arrangements because of that. Whatever happens, it's important that both parties are treated fairly. More about that in a moment. There has been, or potentially will be, some possible changes in fact-finding hearings. I want to explore those at the moment. Things are slightly in the air, but nevertheless, I'll explain that in a moment as to what is happening. Now, fact-finding hearings have recently been the subject of scrutiny by the Ministry of Justice and the courts. Now, what I've said currently stands as good authority. There is the possibility, however, that changes could take place at some time in the future. Following the cases in the Court of Appeal of Re HN and others in 2021, the court raised a number of important points. First of all, it was accepted that Practice Direction 12J remains fit for purpose in providing the courts with a structure on how to approach private law cases when allegations of abuse are made. Within the Court of Appeal hearing, specific guidance was given by the court in relation to whether there should be a fact-finding hearing at all and the use of Scott schedules. Both matters I've just been through. The court heard submissions from the parties as to the usefulness of Scott schedules, and the court's focusing on a list of specific incidents, each tied by time and date, rather than whether there has been a pattern of behaviour. The parties had also been required to limit the number of allegations to be tried. The court concluded a number of matters, and I'm going to read what they say. First of all, serious thought is now needed to develop a different way of summarising and organising the matters that are to be tried at a fact-finding hearing. Quite how a move away from the use of Scott schedules is to be achieved and what form any replacement pleading might take place does, however, raise difficult questions. The process before this court has undoubtedly confirmed the need to move away from using Scott schedules. The court is plainly not an appropriate vehicle to do more than describe the options suggested by the parties, because there are quite a lot of parties involved in this case. It was like a test case. It will be for others, in other words, Parliament essentially, to develop these suggestions into new guidance or rule changes. It also went on to say the court also considered the approach in dealing with controlling and coercive behaviour. The court said that until new guidance or there's been a change of rules, the cases of domestic abuse will continue to come before the court with an increased focus on controlling and coercive behaviour. The court determined within that case that where a party properly raises the issue of whether there has been a pattern of coercive and or controlling behaviour, it is the responsibility of the individual judge or bench of magistrates in each case to set a proportionate timetable and to maintain control of the court process where it has been determined that a fact-finding hearing is necessary. It is, however, our expectation that in cases where an alleged pattern of coercive and controlling behaviour falls for determination, and the court has made that issue its primary focus, the need to determine a range of subsidiary date-specific factual allegations will cease to be made. So what the Court of Appeal in HN was saying was that traditionally we've always had allegations in 1, 2, 3, 4 on certain dates. But sometimes clients will say, well, I can't pin it down to a particular date. It's over a period of time. And HN seem to be saying, well, that's right. You can't ignore the fact that patterns of behaviour get overlooked simply because you can't pin them down to times and places. And so I think that's something that we'll no doubt be looking at. One other matter that came out of the case of HM was the Court of Appeal made it clear that criminal concepts should not be imported to the family court. And there was a reference made to a case of Re R in 2018, where it was held that as a matter of principle, it was fundamentally wrong for the family court to be drawn into an analysis of factual evidence in proceedings relating to the welfare of the children based upon criminal proceedings and concepts. It should be stressed, of course, that this guidance given by the Court of Appeal has no formal legal authority at present, but it's likely that changes will be made, certainly on issues such as domestic abuse. You may even see it applied in some of the courts already that you're appearing in. I had a case once where it was raised and the district judge simply responded by saying, it is guidance after all, I'm not bound by it, of course. And so the district judge gave short shrift to any argument that we were moving away from the way that we've approached these cases over many years. More recently is the case of AA and BB. And of course, that was in 2021, involving private children proceedings. This case is one of the first reported cases to consider the implications of Re-HN. In that case, the appeal was against a case management decision to exclude evidence from a fact-finding hearing. The mother relied on the dicta of the Court of Appeal in Re-HN regarding the limitations of Scott's schedules and the fact that the court focused on particular allegations rather than looking at patterns of overall behaviour. Even more recently, the Court of Appeal has heard the case of K&K in 2022, which states, this judgment is intended to provide general guidance on the proper approach to fact-finding hearings in private family proceedings, following this court's decision in Re-HN. I'd recommend that you download that particular court case because it's very useful in terms of knowing exactly what happened. But my own summary of the principles of K&K are these. First of all, the nature of the allegations and the extent to which those allegations are likely to be relevant to the making of the child arrangements order. My simple way of looking at it is simply say, are the allegations going to take us anywhere? Are they particularly appropriate and relevant? The second principle is that the purpose of the fact-finding hearing is to allow assessment of the risk to the child and the impact of any abuse on the child. Thirdly, whether fact-finding hearing is necessary or whether other evidence suffices, and whether the fact-finding hearing and whether fact-finding itself is proportionate. The court expressed concern that a perception had formed that Re-HN created a requirement that in every case in which allegations of domestic abuse are made, the court should conduct a fact-finding exercise with a detailed analysis of each specific allegation. The Court of Appeal reiterated that the court's duty is limited to determining factual disputes that are likely to be relevant to deciding how to make a child arrangement order. The emphasis now placed by the Court of Appeal on the relevance and effect of the disputed facts was expressed simply at paragraph 45, and I read that to you. Without in any way resigning from what is said in Re-HN about the pernicious nature of domestic abuse, fact-finding is only needed if the alleged dispute is likely to be relevant to what the court is being asked to decide relating to the children's welfare. I think this case sends a signal to family courts to be more careful when deciding on the need to have a fact-finding hearing. Maybe to be more discerning, in other words. It was sometimes said to me, well, judges will always go for a fact-finding hearing because they don't want to be criticised or appealed against. But clearly the higher courts are saying we do need to be far more discerning. And the fact that what appears to be domestic abuse and does have a relevance to child arrangements order needs to be looked at carefully. Another issue which I found interesting in K&K is the question of mediation. In some respects, it could be seen as an unrelated issue within the case, but it did prove to be very pertinent. The court said in K&K that it was unfortunate that the parties in that case did not take advantage of mediation. Now, the interesting thing is that historically what we've tended to do is we've thought, well, there's allegations of domestic abuse, therefore mediation is not appropriate, and we opt out of mediation completely. What K&K is saying is that had mediation taken place, it could be that the issues could have been agreed. So the fact that there are allegations of domestic abuse doesn't mean that mediation should not take place. In fact, quite the reverse. And that the court used the case to make a point to the parties and to others that whilst it had the chance, it should make it clear that matters should be resolved by way of mediation, at least attempted, despite the allegations of abuse. So let me summarise what we've looked at already. In an application for, say, a child arrangements order, that's a C100, Cafcass will carry out their checks and report to the court. In that report, there may be issues of domestic abuse raised. The court will then decide if a fact-finding hearing is necessary. If the answer is yes, directions will be made for a Scott schedule, response and statements by both parties. A hearing will then take place when both parties will give evidence and be cross-examined. The court will decide on whether the facts are true or not and give reasons for that decision. A further hearing on the application itself will then take place. But there may be other directions. It may be that in the light of the court's decision, say there's a finding of domestic abuse, then would a Section 7 Children Act report be helpful in the case? And once the court has got all the information and maybe had a fact-finding hearing, the court will then decide on the issues as a whole. Perhaps more importantly, is contact going to take place? And if so, in what terms? So a few practical issues, if I may. The first is it is more common to see fact-finding raised in safeguarding letters. My own experience is that the Cafcass officer will tend to say the court may wish to consider fact-finding hearing, but maybe go as far as saying we believe that a fact-finding hearing is necessary. Remember, it's for the court to decide, not Cafcass or indeed the parties. So sometimes Cafcass makes a clear recommendation, but often the word consider comes up quite often, maybe sitting on the fence. In either case, you'll need to be prepared to argue the point on whether a separate fact-finding hearing is really necessary. And you could be on either side of the case there. Courts have historically taken a cautious approach in directing a fact-finding is necessary. But recently, there has been a more discerning approach in my experience. Don't assume that as Cafcass has raised the point, it will inevitably lead to a fact-finding hearing. Remember K&K. If both sides are legally represented, you can discuss the need for a separate fact-finding hearing. And also with your client, what does the client think? But if you're thinking in terms of a fact-finding hearing, remember there are consequences. In addition to the issue of raising the temperature and perhaps the feelings between the parties, we need to recognise that there will be more work on Scott schedules and statements, which of course very often in these cases clients are having to bear the cost of. There will be a delay, especially with the court being so busy and difficulty in court listing. It could sometimes be several months before a hearing can be listed. And so you're going to have to wait. And of course, one of the parties may not have had contact, and I'm giving contact as an example, for some time already. So it will have consequences. But perhaps maybe the most important issue when dealing with fact-finding is it really necessary? Is it going to take the matter any further? And I did a case not so long ago, and the case is still going on, where the court had gone through a process and I came into it so halfway through. And there'd been a lot of debate over fact-finding hearing. And when we went before the court, both sides were represented. We concluded that despite what had gone on in the past, that the fact-finding hearing wasn't taking matters further. The court accepted that and concurred that there shouldn't be a fact-finding hearing, and we could deal with matters generally within the case as a whole. So whatever's happened in the past, continue to consider the need for a fact-finding hearing, even though initially there had been an indication by the court that it was necessary. I'd now like to look at the subject of litigants in person in fact-finding hearings. You may know that many private children cases involve at least one party not having legal representation. Now, I've already indicated that statistics are in short supply, but the latest figure that I've seen is that only 25% of private children cases have both parties legally represented. This means that around 75% of children cases involves a litigant in person. Now, if that's the case, the court needs to think carefully how it handles cases where one party, often the victim, is represented and the alleged perpetrator is a litigant in person. In my view, a number of issues arise. First of all, making sure that the correct issues are put in writing, including the Scott schedule and the witness statements. Now, for a litigant in person, this is not always easy or straightforward. The second is your role in guiding a litigant in person at the hearing, which has no, and of course the litigant in person is likely to have no experience, including whether he should give evidence himself or not. Making sure that the litigant in person understands the significance of the findings. Allowing the litigant in person the opportunity to cross-examine the other party who may be making serious allegations against him or her. My own experience is that it depends on who's hearing the case. Many district judges are experienced at handling litigants in person and ensure there is fair play. They go out of their way to make sure that both parties are heard well, will take up questions for cross-examination, and historically ask them on behalf of the litigant in person. Things have changed, of course, and I'll go through that in a moment. Lay magistrates will vary, but I think we have a professional responsibility to try to correct the position as best we can. But there, of course, are limits as to how far we can go. We do have a duty to the court, as well as to our client, of course. And you may feel that the litigant in person is on his own or her own. But there are things that we can do to make sure that things happen and adopt a fair approach to the case. Now, according to the most recent version of the Equal Treatment Bench Book, which is the guidebook that judges use, at any court hearing, a judge should aim to ensure that litigants in person understand what is going on and what is expected of them at all stages of the proceedings. Before, during, and after any attendances at court. The court process itself, especially if a represented party is being oppressive or confrontational. The key for the judge is to maintain a balance between assisting and understanding what the litigant in person requires, while protecting their represented opponent against the problems that can be caused by the litigant in person's lack of legal and procedural knowledge. I think it's fair to say that most courts acknowledge that dealing with a case involving a litigant in person is very difficult. The judge treads a fine line between making sure a hearing is productive and worthwhile, while at the same time ensuring that the unrepresented party has a fair and proper hearing. A litigant in person is expected to comply with all the court rules and procedures, as confirmed in Barton and Wright-Hassel as far back as 2008. But there will often be a need to take a more flexible approach in family cases, as stated by Lord Justice Mumby in Re C in 2012. So when you go into court, it may be the judge is perhaps giving the litigant in person more latitude than he would if he was represented. Now, a fairly recent case in the Court of Appeal revealed that a judge can go too far in attempting to direct the case in a particular direction in order to assist the court process. I want to explain a little bit more about this case of Re Inkster in 2020, where the Court of Appeal was satisfied that the circuit judge's uninvited intentions and the consequent impact upon the unrepresented appellant created inappropriate pressure on the appellant's freedom of choice. The appellant had pleaded guilty to 3 counts of breach of non-molestation order and was sentenced to a conditional discharge for 6 months. The primary ground in the appeal was the appellant's decision to change his plea and whether it was a voluntary choice. The pressure placed on the appellant by the judge resulted in the appellant feeling that he had no choice but to plead guilty. The appellant was unrepresented at the hearing in the lower court and argued that he was in unfamiliar environment, which he was. That's undeniable. At the appeal, it was suggested by the Crown that the appellant was an intelligent and articulate man who chose not to be represented. He understood the process and engaged with it. He understood the law and was capable of representing himself. The Court of Appeal rejected these arguments as the trial judge had effectively advised the appellant as to the particular course of action. The moral of the story is that the judge must exercise his or her role with great care when dealing with a case involving a litigant in person. The judge appears to have attempted to assist the case by expressing his view in such terms that the unrepresented party felt he had no choice but to follow such advice. This was clearly exceeding his role, and such intervention proved to be incorrect in law. Now, I thought this in particular was interesting, that another aspect of this case was the involvement of counsel for the Crown at the first hearing. He volunteered to speak to the appellant during the luncheon break and act as a wise ear. Counsel appears to have given advice to the appellant, which may have led the appellant to believe that he should follow the judge's indications. He seemed to have done so with every good intention of assisting the court as well as the appellant. But the Court of Appeal took the view that by meeting with the appellant, counsel may have made the situation worse. Now, whilst that case was a criminal case, the principles in handling a case involving a litigant in person still stands generally. So we do need to be aware of the fact that whilst I think there is a professional responsibility to help litigants in person, we have to be careful about how far we go and what our role is. And inevitably, it's going to impact on fact-finding hearings. Another case that I want to draw your attention to, and you'll find it in the notes, is Rea and Rea in 2022. And that was a case in the Chancery Court where the judge intervened. The litigant in person was challenging some of the facts of the case. And the judge allowed some of them, but at a point stopped them. And the Court of Appeal criticised the judge for doing that, saying that in a finding of fact hearing, which effectively it was within civil proceedings, we must allow litigants in person to have at least a fair amount of latitude in what he can and cannot do. Now, for some time, the judiciary has called for the provision of an advocate to ask questions of a vulnerable witness on behalf of a litigant in person. So we're focusing now, of course, on family proceedings specifically. And the introduction of a power for the courts to appoint what is described as a qualified legal representative to undertake cross-examination under the Domestic Abuse Act 2021. Now, of course, this is especially important in fact-finding hearings. So a person convicted of or cautioned for or charged with a specified offence is prohibited by statute from cross-examining a witness who is the victim or alleged victim of that offence. And Section 31S protects the party against whom an on-notice protective injunction is enforced, so it extends itself to injunction cases as well. And it's fairly wide-ranging. And what the court effectively have to do is this, that where cross-examination is prohibited, the court must consider whether there is a satisfactory alternative means for cross-examination. And if there is no satisfactory alternative, the court must invite the prohibited party, usually the person who's accused, to arrange for a qualified representative. Now, very often they won't do that because that's why they're litigants in person. So if that invitation doesn't solve matters, the court must consider whether it is necessary in the interests of justice for a qualified legal representative to be appointed by the court. And the legal aid system will pay for it. Now, up until fairly recently, I found that the court had been fairly slow. But it's worth knowing that the change came into force on the 21st of July 2022, but only applies to proceedings commenced after that date. And I had a few cases where it would have been nice to have had one party, I suppose, looked after by the qualified legal representative. But the proceedings were commenced before that date, but they are coming through. And initially, I thought it was fairly slow, but I'm finding now, because I happen to be on the list of qualified legal representatives to represent the client. And I've got a court order that came to me, it's dated the 2nd of October, saying, and it's made by the Derby Family Court, which is where I practice part of my time. The court appoints Stuart Anthony Barlow to conduct cross-examination on behalf of the prohibited party, namely the applicant. The court-appointed qualified legal representative must notify the court as soon as possible if they're subsequently unable to accept the court appointment. The respondent legal representative shall send the court bundle to the qualified legal representative appointed to conduct cross-examination 7 days before the hearing with cross-examination. And so what we have now is a fact-finding hearing. So if you've got a litigant in person, and remember, of course, that we have an enormous number of private law proceedings for children with litigants in person involved. We're now going to have these qualified legal representatives. Now, if you're interested in that and are able to conduct the case on behalf of the court, and I emphasize the court, then please sign up, because I think there is a shortage of people to be able to do it. But I just want to give you a flavour of what the job involves. And on this, we'll bring our time together to an end. And if you've got any questions, please fire away. But a qualified legal representative is not the solicitor or legal representative of the party. He or she is appointed by the court, and they will receive instructions in the way that that court order reflects in appointing me. I meet with the litigant in person, having read the papers involved in the case, and I decide on cross-examination. The litigant in person is not my client, and I don't have to cross-examine on questions that they choose to do. Now, it could be that I believe that questions that the litigant in person would normally ask would be ones that I would ask. It could be also that he or she hasn't come up with any questions, in which case my job is to decide on the questions of cross-examination. So in practice, what will happen is that I come to court, I meet the litigant in person, I tell them what my role is, that I'm appointed by the court and not by him. There is no solicitor and client relationship, and the costs are borne by the legal aid agency in order to do so. Once I've cross-examined, my role ends and I simply leave court. I do not make any submissions. I'm not there to represent the client to bring about a particular conclusion to the case. I am simply there to cross-examine. And I think it's early days, because it's going to be most of us who've been cross-examining on behalf of clients and working with them to that end are going to find the role somewhat unusual. But that is a particular role. And if there's one particular big change in fact-finding hearings in private law proceedings, it's that. And I think it's fair to say that I have a request at the moment of 2 or 3 times a week from various courts. I practice in Nottingham and Derby, but I'm getting requests to attend court in Newcastle, in Wolverhampton, and other courts round about, as well as local courts here in the East Midlands. So be aware of it. And if you have a fact-finding hearing and you have a litigant in person on the other side, it may be that you will receive notice of the fact that a qualified legal representative will be appearing in the court, in which case you will know what the role of that person is. Now that brings us to the end of this session together. It's lunchtime, so many thanks for your attention. I'm sorry that we didn't work with the slides, but best wishes in your work amongst fact-finding hearings, and in particular with litigants in person. Thanks very much indeed.
Well, Stuart, thank you very much indeed. And that was very interesting, but I was particularly fascinated by the prospect of more work for lawyers, which can't be a bad thing, can it? And
but one of the criticisms apparently of the system is that the legal aid rates given to the qualified legal representative are very low.
Ah, that might be a bit of a disincentive.
Yes.
Anyway, Stuart, thank you very much indeed. We will be seeing more of you this afternoon.
That's right.
But now it is lunchtime, and I think we can run a bit longer than 10 minutes to 2, which is down on the timetable. So let's say, well, 5 to 2. An extra 5 minutes won't do any harm. So I'll see you back here at 1:55, and we'll be hearing then from Gemma Lindfield. So see you then, everybody. Bye-bye for now. 5 to 2, which means that we're going to be hearing very shortly from Gemma Lindfield. And Gemma, if you are here, if you'd like to turn your video on.
Hi.
Hello, Gemma. Well, I hope we're going to be joined by everybody. I think we've got 58 people still down there listed with the participants. And Gemma, you're an experienced extradition, family, criminal, and public law barrister, and with a particular focus on human rights. And you're going to be telling us about children arbitration. So we'll be looking forward to hearing from you. I'm afraid.
Hello.
Oh.
Can you see my screen?
I've been asked to start my video. I couldn't start it before, but I can now. Okay. So I think, Gemma, you've got some slides for us?
Yes. Are they up on the screen?
Yes, indeed. The first one is there. The previous speaker, Stuart Barlow, was having a problem with his slides, but it looks as if yours are going to be coming through all right.
Yes.
So,
excellent.
Well, Gemma, over to you. And
Thank you.
maybe I could just mention our chat box and Q&A box are open for questions and comments. Right.
Yes.
Thank you.
Excellent. I'm not sure how I'll see those when I'm screen sharing, but I'll work that one out. So I wanted to talk today about children arbitration, although it will touch on financial arbitration. There's obviously significant similarities between the two. Just wanted to ask the audience, really, how many of you have been involved in an arbitration? Can I see? I can't see the chat box for some reason. Chat. Is there anyone that's been involved in arbitration that would mention in the chat box? Yes, Joe has. I assume that might be the case. It's something that's not really utilised enough, I'm going to say. Also, full disclosure, I am training to be an arbitrator under the children's scheme next month. So hopefully in the new year, I will be an arbitrator. I see it as an important role within the family justice system. Although it's outside of it, it's definitely a useful tool. Find it, as I'm sure many of you do, if not all of you do, incredibly frustrating to have cases that take many months to resolve, and sometimes where there are limited issues between the parties, and particularly those cases, the ones that concern me are the ones where there's sort of, broadly speaking, there's a lot of agreement, but as time rumbles on, give people time and they'll find things to disagree about. And that aspect of delay is bothersome. You know, we all agreed about Christmas, and then Christmas came and we now don't agree. You know, that's incredibly problematic, and that's really the court system unraveling co-parenting. So that's what sort of drew my interest to it, is just seeing how, observing how the court process can really unravel matters. Just some stats for you. The Family Justice Council keeps a record of applications. So in the second quarter of 2023, there were 13,080 new private law applications. That was down 4% on the equivalent quarter in 2022. 19,000 children involved in those applications. the delays in the system are still significant. In April to June 23, it took on average 47 weeks for private law cases to reach a final order, which is up three weeks from the same period in 2022. And we see this upward shift, which is obviously very concerning. There is evidence. I mean, do we need evidence? I think sometimes we can have evidence on things that it's self-apparent. But there was a study by the Early Intervention Foundation looking at the role of prolonged conflict on children. I've hyperlinked that in my paper, but there's evidence that prolonged conflict between separating parents is harmful to children's well-being and life chances. Starting off as a criminal lawyer representing youths in court, you know, it's slightly disturbing that the prolonged conflict in the family courts might be putting children into that arena. Research shows that exposure to interparental conflict is associated with higher rates of anxiety, depression, aggression, hostility, antisocial behaviour, criminality, reduced academic performance, and substance misuse. So it's pretty, I mean, obviously it's not going to happen in every case, but it's the fact that there is then an increased level of those harmful behaviours. So using the family courts to resolve private disputes involving children can often lead to lengthy conflict between parents and carers, and then could result in children experiencing significant periods of time where the settlement, it takes a while to arrange suitable arrangements. And we all know, no matter how much we say to our clients, and the judge will say to our clients, don't tell the children adult things, don't tell them too much about the court, keep it to the bare minimum. They overhear things, even the best of parents. So it is incredibly concerning that's what the impact that the system can have in some cases. So set against that backdrop, I'm going to suggest that many practitioners don't consider arbitration as an option for their clients. And I'm going to suggest that this should be something that's up for consideration. Obviously, there are cases, and we'll come on to that, where it's not possible to arbitrate. But standard cases where there aren't safeguarding concerns that qualify for the scheme, it is something to be considered. I think there's also, I was talking to two solicitors yesterday evening, and they've both been involved in one arbitration each. And interestingly, one of them, the case, as it were, the life of it in terms of conflict resolution started in arbitration from beginning to end, 6 weeks for a decision, which I think is incredible. To think that that those parents and those children can then just go on with their lives, and hopefully that's the only brush they have with a decision maker making decisions for their children. In respect of the other case, it was a move to arbitration because the court system was taking too long. And they ended up arbitrating both the finances and the children. They just took it out of the court system entirely on both bases. So that was interesting, because one of the solicitors believed that you had to start in the family court process to be able to arbitrate, but obviously that isn't necessary. So the IFLA has got schemes. The schemes are as a result of a collaboration between Resolution, the Family Law Bar Association, and the FLBA, and the Chartered Institute for Arbitrators, and the Centre for Child and Family Reform. There's a hyperlink to them. and that's who I'll be doing my training with next month. The Family Arbitration Financial Scheme has been operational since 2012, and I think although you've not been involved in arbitration, you probably have been involved in mediations in the financial setting where people have come to, you know, or there's private FDRs or even the FDR process, and perhaps it thought to lend itself more to financial cases. But in 2016, the children's scheme was introduced and is governed by its own rules. Self-evidently, the law of England and Wales is the only law that can apply to the arbitrations under both schemes. So what are the benefits? Firstly, speed, as you've heard, 6 weeks, you know, I'm not saying that that's what they can all take, but it can be dealt with swiftly. It's less adversarial in that, although obviously the parties have their positions and they're seeking a determination from an arbitrator, what page are we looking at? We are looking at page 2. I've not put everything on the slides that's in the paper. So it's less adversarial, although they're having a decision imposed upon them. The process is less adversarial in that it is more, they have to come to arbitration by agreement. They're effectively agreeing that will be the final step, although we'll come on to grounds for challenge. It's very flexible, which I'll come on to, where you can control the aspects that you want the arbitrator to look at, and so it's not as adversarial as the court system. Again, I'm going to suggest partly because of the speed as well. I think there's something about the court system and the adversarial nature of it and the delay that can just bake in petty conflict. Continuity is a very important one. I mean, how many times have you had a case where the same judge has been involved throughout? With arbitration, you appoint an arbitrator, and then you have that arbitrator throughout the life of your case. Flexibility and control, obviously you have complete control over the dates, so it can be fixed for the parties' convenience, which is obviously very different to the court service, just deciding many times to list a case, and the parties have to be available. I mean, certainly there are certain jobs that, you know, teachers, for example, having dates that are in summer holidays, for example, or holiday time. And there is more control because you can be very creative. Cost, I think, might be a controversial one because obviously you have to pay the arbitrator's fees. But I'm going to suggest again that with delay, you get inbuilt cost because, for example, if you have a final hearing in 6 months' time and there's issues with the arrangements in that period, there's going to be correspondence, there's the emotional cost. Also, it can be very frequent that cases are stood out at short notice where you've prepared for a hearing, you've got counsel instructed. So although there is a cost for the arbitrator, which is something that is obviously very different to a judge where you've got court fees, but the judge you don't pay for, the speed can mean that it's actually less costly to go through this process. It's also, confidentiality That's really as a result of the fact that obviously there's the family court reporting piloting scheme, which is permitting reporters and bloggers to attend private law proceedings and report on them. Obviously, those rules don't apply to arbitration. Can I just check everyone can hear? Because I've just seen a question and answer saying, can everyone hear? I will assume yes. So what cases can be referred? The following: where a child should live, spend time with arrangements, health and non-life-threatening medical treatments, education and religious issues, and relocation to a Hague Convention country. Education issues, this is obviously something that, I mean, on the current timescales for hearing cases in the family court, it's incredibly likely that any application relating to a specific issue concerning education is just not going to get heard in time. Had a case a couple of weeks back where there was a specific issue in relation to education, which needed to be made within a month. Solicitor listed it as urgent. Court said this isn't urgent, sorry. So that decision will not be made in the timescales for the child. However, as long as you've got the time and the ability to prepare the case for arbitration, appoint the arbitrator, that's something that you can utilize. So I would say particularly some specific issues which are time limited, arbitration really is your friend. What can't be referred to the scheme? So where there are safeguarding issues, obviously we heard the informant talk about fact finding. Anything where there is domestic abuse should not be in the scheme. Applications for a child's return or removal from the jurisdiction, relocation to a non-Hague Convention country, which obviously makes sense because if there's a relocation to a non-Hague Convention country, then the parent that's left behind obviously can't avail themselves of, for example, Hague contact applications. Disputes in respect of life-changing or life-threatening treatment, any dispute where a person under 18 holds PR for a child, so quite a narrow scope there, and any case where a party lacks capacity. So I'm going to suggest that the list of things that can't be referred is quite, in many ways, it's sort of common sense. So what you're looking at is your straightforward children applications. So as I mentioned, parties can go straight to the arbitration scheme for determination without having entered the court's arena. Parties can also enter into arbitration once proceedings have commenced, perhaps frustrated by delays. If there are subsisting proceedings, then the court should be invited to stay the application pending delivery of the determination by the arbitrator. It would be unlikely, although I guess in our job it's always possible, that there would be a contested application for a stay. If you've appointed an arbitrator jointly, it would be a little bit curious. And any application needs to be made on notice to the court that's dealing with the proceedings. The family court has an obligation under FPR at 3.41b, where the parties agree to enable non-court dispute resolution to take place. So that will be your ground. And section 994 of the Arbitration Act 96 requires a court shall grant a stay unless satisfied that the arbitration agreement is null and void, inoperative, or incapable of being performed. So I guess, again, if you had applicants who very obviously were in the list of no-go cases, then the court would be the gatekeeping there and would say, no, you're not, sorry, it doesn't fall within the scheme. But again, it would be slightly curious if an arbitrator had been appointed and everyone had overlooked that they were conducting a case that it wasn't possible to conduct. In the case of a children arbitration, the parties will have agreed that they will apply for a consent order to a stay of any existing court proceedings as necessary. And so it generally will be dealt with on paper because it's not contested. Parties seeking a stay should provide clear evidence of their agreement or lack of opposition to the stay order, together with a copy of their signed arbitration agreement. And there's standard orders approved for use in relation to that application. How do parties commence an arbitration? Well, they complete an ARB1CS form, which we'll try and take a look at in a moment if I can battle with the technology to change my screen. And then they also provide a DBS check, so maybe through Police Scotland, or if there is if it's already been in proceedings, there's a Cafcass safeguarding letter or any local authority documents. Perhaps there's a CAF assessment that concluded that there wasn't any safeguarding. These would be documents that you would need to provide to the IFLA, who are responsible for appointing the arbitrator. Let me see if I can just... So can you all see that? Hopefully. That is the form that you complete. And it's a very detailed form. This is the most up-to-date one. You put the applicants' names, the respondents' names, all the usual things that you would expect. Representation. You don't have to be represented in arbitration, but it's probably likely. The children, the dispute concerning the following issues. So you set out what the specific issues are that you wish to be addressed by the arbitrator. Then you have a section on the nomination. So there's 3 ways that you can, that the IFLA can appoint a member of the children panel. The first is you're all agreed, happy days, we would like to appoint this person. We both think they're fantastic. That's who they are. An alternative way, and one that's probably quite used frequently, here are a pool of arbitrators. We all think they're good enough, and we'd like you, the IFLA, to choose one. Or we haven't even been able to agree. I mean, that's a bit of a worry, but we haven't been able to agree even a pool of arbitrators. So we would like the Institute of Family Law Arbitrators to nominate a member of the panel for us. Then at 6, if there's any court proceedings, please identify the nature of the proceedings have reached. Number 7, dealing with safeguarding. So provide the following: a safeguarding questionnaire is attached to the form, completed and signed by each party, together with either basic disclosure from a disclosure and barring service or from Disclosure Scotland as appropriate. Or alternatively, an up-to-date Cafcass report or Schedule 2 letter prepared in current proceedings, and then any other relevant letter or report prepared by Cafcass or local authority, children's services or similar agency in relation to safeguarding. So if there are a number of those documents in the ether, then they would need to be attached. And then there's a confirmation from the parties that they understand and have been advised about the nature and implications of an agreement to arbitrate. Once the arbitration started, that they won't commence court proceedings in relation to the same subject matter unless it's appropriate to make an application to the court arising out of or in connection with the arbitration, or some relief is required, that would not be available in arbitration. So, for example, if a safeguarding issue arises, that would be an exception. And that they've read the current edition of the rules of the scheme, and that they'll abide by them, and then they agree that they will provide and do certain things. And they obviously are agreeing that they will, at all stages, they will comply with the decisions and directions and orders of the arbitrator, and that they understand and agree any determination is final and binding on them, subject to any of the followings, and we'll come on to challenge in a minute. And so far as the subject matter of the determination makes it necessary, that they will apply for an appropriate court for an order in the same or similar terms as the determination or the relevant part of the determination. And they'll take all reasonable necessary steps to see that such an order is made. Obviously, they understand that the court has an overriding discretion in relation to orders that it makes. And that they agree that they will bear an equal share of the fees and expenses. And then there's obviously an important box where they're accepting the process, and that it is a binding agreement upon them. So that's then there's the safeguarding questionnaire at the end, which again is going to catch those sort of domestic violence, child abduction, child abuse, drugs, alcohol, substance use, safety or welfare concerns. So that's what the form looks like. Just going to get back hopefully to the slideshow. The rules largely work on self-declaration, but it's also, there is a 2018 practice guidance from the President, and I've referenced paragraph 5 and 6 in my paper, but basically what the President wanted to underscore was that the welfare principle requires the safeguarding is a fundamental element of any child planning dispute resolution, whether conducted via the court or by ADR. And there are two aspects to safeguarding in a child case. First, providing for the physical and emotional safety of the child concerned and the parties in the immediate time frame of the dispute. Second, taking appropriate care not to make an order or provision that will put the child concerned or the parties at avoidable future risk. Going on in applications under the IFLA scheme, the parties will have completed a safeguarding questionnaire and obtained basic disclosure from Disclosure Scotland. The attention of the parties and the arbitrator in any proposed arbitration is also drawn to 5.1 and 5.2 of Practice Direction 12B, which advises that the process of non-court dispute resolution is unlikely to be appropriate in a situation involving domestic violence, drug and alcohol abuse, and mental illness. So once the form is submitted to the IFLA, an appointment is offered to an arbitrator. The arbitrator then seeks the parties to agree to his or her terms. Each arbitrator have their own contract. Once that's all the T's and C's are okayed, the arbitrator accepts the appointment and the arbitration formally begins. The arbitrator will contact the parties to progress the arbitration by agreement or after considering the parties' positions as directed. So you might, in your role as an arbitrator or in your role as a respective advisors, you would be thinking about what will the parties agree to progress this? What directions are needed by the arbitrator, and if there isn't agreement, then the arbitrator will simply decide. So there might be, for example, a disagreement about, and we'll come on to this, whether an independent social worker should be involved, and the arbitrator might say, I need one in this case to be able to determine this matter, and so that's what will be directed. There's often a preliminary meeting. It doesn't have to be very long, just to address the way in which the arbitration will be conducted. It isn't compulsory, but it is very helpful, even if it's just a short meet and greet, and everyone knows where they are and what they can expect. An arbitrator is prohibited from meeting the child. An independent social worker or other expert can be appointed to ascertain the wishes and feelings of the child or children. If during the process, so Article 17 of the rules requires an arbitrator to have continuous regard to safeguarding throughout the process. So I guess if the arbitrator was concerned about the presentation of one of the parents, or something that's concerning them, that there's some safeguarding risk, and they can appoint an ISW to look into this, to satisfy themselves that this is actually something that they should be dealing with. Wide-ranging powers. It can be very creative. Wide-ranging case management or substantive decisions. The arbitrator can decide what issues should be included. They can appoint an expert or an assessor. They can decide evidence required, the amount of disclosure, the need for written submissions, and whether oral hearing is necessary. Like I say, they can appoint experts even if the parties do not seek one. Third parties can be joined if agreed, provided that they accept the rules and determination of the arbitration. I guess if you've got a partner of one of the parties who has a significant role in the child's life, that would be someone that you might want to get involved. If one party fails to comply with the directions, then the other party can apply to the court for an order requiring compliance. And points to note, there is an ongoing duty to disclose once the arbitration commences. I guess that's the most applicable in financial cases, but there are things that arise in children's cases. So I guess an example, say one of the parents gets arrested for drink driving. That's something they're going to have to tell you that. Communication is never ex parte. As I said, the parties don't need to be legally represented. Practice Direction 27A regarding bundles doesn't apply. So a bundle can take whatever form it's agreed or decided. Probably going to look a lot like Practice Direction 27A. But again, there is that freedom to decide what is going to work best for the parties. I don't know if you have this experience, but sometimes bundles and the contents of bundles can be a source of much dispute. A disproportionate amount of time, I think, spent on it. The parties obviously need to consider practicalities. How long will the arbitration take? How long do we think is needed? Where should it take place? You know, it could take place in barristers' chambers, for example, or a neutral third place. Can it take place online? The initial meeting, for example, why not? Why not all of it online? Should it be recorded? Is it necessary for there to be all evidence for the arbitrator to determine this issue? How adversarial do we want to make this? Should that evidence be sworn as a reassurance? What's also important to remember is that the no order principle extends to any agreement to arbitrate and the outcome of an arbitration. If the parties simply agree to manage their arrangements in accordance with the determination, then there's no need to have a court order to reflect it. And I think that's what probably sets finances and children apart, because obviously you need that order under the Matrimonial Causes Act, whereas with children it's different. Do you even need an order? If these parents, I mean, for example, particularly if a decision, a specific issue order, you know, if little Johnny's going to this school, fantastic, let's progress the application. Do we need a court order? Do we need to clog up box work for judges? I think we don't. The determination is given in writing unless otherwise agreed by the parties. I mean, sensibly, it would make sense to have it in writing. There are two parts to it. The first is the narrative reasons, like a judgment. Second is the determination, which is like an order. There might be a need to address costs and other points, like undertakings, before determination is finalised. Obviously, undertakings, that's something that then that's going to kind of dictate whether you need a court order. You can also issue a draft determination and embargo it, and if you might want to invite comment on something. Consent order, question mark. I've already touched on this, but paragraph 8 of the practice direction recognises that the parties might seek a consent order for various reasons. For example, having regard to the context of the history of the dispute to avoid the risk of relitigating the same issue in the future, in order to obtain confirmatory order for production to non-parties such as medical and educational authorities, or to obtain an injunctive or other form of order via family court processes reflecting the determination, and which will only be available if orders reflecting the determination are obtained. A consent order will be drafted to reflect the decisions and directions contained in the determination. The form should follow the relevant paragraph of the standard family orders, which contains recitals for an arbitrary determination. Hi. Just seen a note saying hi. I don't know if there's supposed to be another part to that, but hopefully you can still all hear me. The consent order basically the parties should at the same time, if there is if proceedings have already started and have been stayed, then it's simply a case of making an application on a C2. If there is no extant application or proceedings, then the parties will obviously have to lodge a form C100, and with the applications for a consent order, a copy of the arbitrator's decision should be provided. If it's not already on the court file, the arbitration form that was completed by the parties. In SS financial remedies, in 2014, Mumby, the president, said where parties are put in the matter before the court by consent, it can only be in the rarest of cases that it will be appropriate for the judge to do other than approve the order. And again, really the exceptions would be paragraph 7 of practice direction 12J, prohibiting the court making an order unless safeguarding checks are complete or satisfied that there is no risk of harm. If the parties wish to maintain the confidentiality of the determination, they can lodge the arbitration determination in a sealed envelope, clearly marked with the name and number of the case and the words arbitration determined confidential, not to be opened without permission of a judge of the family court. So that's not, I thought that's for me, that's a question. So the question is, what scope for challenge? That's obviously not what you want, is it? If you come to arbitration, you don't want to be opening up this as a another round or a precursor to court proceedings. There was a decision in 2021 which was concerning financial arbitration, and the family court ruled that it is possible to challenge an arbitrarial determination. The court in G&G, where there was some magistrates consent order was sent in, and they very properly referred it to circuit judge level, which then it was then referred on to High Court level to consider whether under the children's scheme it was possible to challenge, and if so, was it along the same procedure of Haley and Haley, which we'll come on to, or was there something else? The decision was that yes, the same principles apply to a children's dispute determined by arbitration. A judge being invited to make any welfare order under the Children Act must be independently satisfied that it's a proper order to make the paramount consideration being the welfare of the child under Section 1.1 of the Children Act. Upon making an order after a contested hearing or endorsing an order made by consent, the judge has a duty to have in mind a welfare checklist. So it doesn't matter whether it's by consent or if it's contested, the court has an overriding duty to ensure that the welfare is paramount. So the same it applies for the making of an order following an arbitration determination. Of course, if there's no challenge to the determination, it's highly likely, albeit not inevitable, that the court will make the order, but the parties cannot oust the jurisdiction of the court, and whether the order sought is agreed or opposed by one of the other parties, the court's overarching duty to consider whether the order is consistent with the best interest of the children remains the same. The mere fact that the parties have submitted to arbitration does not prevent the court from scrutinising the subsequent order, and if appropriate, refusing to endorse some or all of its provisions. In G&G, it's a useful decision because it really does take you through what the procedure is. So as Mr. Justice Peel, what the procedure is for a contested arbitration, a contested consent order on the basis of an arbitrarial determination. The legal test, Mr. Justice Peel concluded, considering Haley and Haley, was that is effectively the permission to appeal test. The test is therefore that it's wrong and nothing more, nothing less. And what Mr. Justice Peel noted at paragraph 17 was in the form which I took you through, which I did highlight, that there was a section which says the dispute will be final and binding subject to the following, which is any challenge to the determination, any subsequent determination superseding it, any changes which the court making that order may require. So it is already baked into the form was the recognition that there could be challenge or superseding to the determination. Therefore, there is now a procedure. The procedure is that if there is a dispute, that you can go down one or two routes. You can apply to set aside, but that would be more of an exceptional test. So why would you? You would go down the route of a paper decision seeking to challenge the arbitration determination on the basis it's wrong, and you would send, sorry, forgive me, stepping back, one step. So if you wanted to challenge the determination in sending to the court the application for consent order in the C2, you would record that there is a dispute about the consent order, and the application in Form C2 or in C100 should have the grounds of challenge annexed to it, and also a skeleton argument, and then there's provision for a skeleton argument in response by the respondent, and then the parties agree in the draft order that is available and is annexed to G&G, that the application will be considered either by a circuit judge without a hearing not sooner than 21 days after issue of the application, or the application and accompanying documents to be considered by a High Court judge without a hearing to be allocated upon consultation. One of the considerations that Mr. Justice Peel had, it wasn't strictly part of the appeal, so it's obiter, but he did spend some time on it, is whether or not, and obviously if at the initial triage stage, the judge says, no, there's nothing in this contest, I'm just going to make the consent order, they just make the consent order. Or they could list the matter for an inter-parties hearing to then consider whether or not the consent order should be made. And then obviously it's within the discretion of the court how they then play things out after that.
But
Oh, hello.
Sorry, darling.
The question that arose is whether or not either party has a right to appeal the determination of the judge on whether or not the consent order should be made on either side. So if the consent order is made, should the party who opposed it be able to appeal? Likewise, if the consent order isn't made, should the party who wanted it made, is they able to appeal? Mr. Justice Peel concluded that they are able to, because it is an order that's been made by the court and it is subject to the appeal process. So that just hopefully is a whistle-stop tour through arbitration. I do recommend, if you're interested, there's a book, Family Law Arbitration Practice and Precedents, and it's by Dennis Sheridan and Suzanne Kingston, who were instrumental in establishing the arbitration schemes. It's an excellent book. It's got everything you need in there. So if you've got an interest in this area, I thoroughly recommend that book. Has anyone got any questions?
Well, I think this is where I come in, Gemma. And you've ended your talk bang on time. Very good indeed, at 2:45. And well, thank you so much for a very interesting talk. And if anybody does have a question, you can get it in now, I think, before Gemma completely departs. Or I guess you can answer it on the chat box or the Q&A, Gemma, if anybody does have a last-minute question. But in the meantime, I can see waiting in the wings Stuart Barlow, who has the second of his talks today, which is the rights of grandparents in children proceedings. So I think without any further ado, just to say that Stuart's talk will be ending at, we hope, 3:40. It might carry on a bit longer, but that's the scheduled time. And then we shall have a tea break. So, Stuart, over to you.
Thanks very much. Let's see whether I can get my screen to work this time. Aha!
Oh, success.
Wonderful. Welcome, everybody, to this second session. If you were with me this morning, I had problems with my slides, but let's hope that it's okay now, and we'll go from there. I'm just going to sort of work things through Just bear with me for a moment. Oh, there we are. Yeah, fine. Okay. Well, welcome to this presentation on the rights of grandparents. There are slides in your notes and also notes themselves, which I hope you'll find very helpful. I'm Stuart Barlow. If you weren't with me this morning, I've been working in the area of family law for a long time now, over 40 years, which has meant that obviously I've been dealing with grandparents. I've conducted most of my own advocacy, and I've dealt with many cases involving grandparents. So I hope what I've picked up over the years will be translated in today's session, and all being well, give you some idea of the way things are. I just want to make sure that I can get my slides going. Oh, there we are. I think. Bear with me if you would, please. Oh, there we are. Yeah, I think we've got it. I've got it posted. Okay, fine. There are about 40 million grandparents in the United Kingdom. Over 1 in 3 are over the age of 50 years. It is estimated that 1 in 3 working mothers look to grandparents for help with childcare. And you may yourself be in a situation where you seek the help of a grandparent, or indeed are a grandparent yourselves. And I happen to have 7 grandchildren. And over some years, we've been involved in the school run. And so we're very much aware of it. This means, of course, that grandparents are an important figure in the lives of grandchildren, as one would expect that in most cases. And if you've been involved in the school run like I have, you can't help noticing how many grandparents are active in dropping off and collecting their grandchildren from school. Most of my family are teachers, and they confirm that grandparents really do play an important part in the lives of many of their children at school. And so, in a sense, that's the start of what we're going to be talking about. So that when the relationship between happens within a family, it's often the grandchildren and their grandparents who suffer on separation. And you may be able to identify with that. When faced with this situation, a grandparent will often ask, where do I stand on this? What are the grandparents' rights? With so much conflict and emotional distress to deal with, it's often difficult for grandparents to know where to start in terms of maintaining or re-establishing contact with their grandchildren. I'm involved in a support group which meets in London, and I give advice to the group from time to time, and we log in every month, and some of them give some fairly distressing accounts, those who actually attend are grandparents, of the fact that they haven't seen their grandchildren. So what I'm saying today, I've seen in terms of my relationship with this group, and there are groups around the country of a similar nature. But so if there is that conflict and emotional distress to deal with, it's often difficult to know how to deal with. But let me start by seeing the sort of questions and comments made by grandparents when facing the loss or potential loss of contact or care of their grandchildren. If you look at the slide in front of you, I've not seen my grandson since he was 5 years old and is nearly 12. We used to see him every other weekend, but his mother met another man, married him, and now doesn't want my son to see his son. I do get upset, but I don't want to make things worse. And another quote, what about grandparents who are not allowed to see their grandchildren? My son fell out with me 9 years ago. I have had Christmas and birthday cards sent back. I would love to see my grandchildren. And another quote, I'm a grandparent. My son separated from his wife last year, and although access to my grandson has not been hindered so far, I feel it could be in the future because of the ongoing conflict between my son and his soon-to-be ex-wife. I am astonished that there is no law to protect grandparents' rights to access. I feel as a grandparent it is vitally important to keep that contact with the child. It's as if grandparents are being penalised for their children's broken marriages and relationships. Grandparents have always been seen as the backbone of the family unit. It would be a shame to deny any child that point of contact. So let's look at an overview of the current law affecting grandparents and their grandchildren. Here we go. Yeah. Now, the Children Act makes no specific reference to grandparents. Even the amendment of the Children Act, what seems like ages ago now, make no reference to grandparents. In fact, the only provision that's mentioned for grandparents is in the section which defines a relative. And almost everybody who is related to the child is referred to in that. So grandparents have no particular place, not even a special place in the Children Act. So for all intents and purposes, it could be said that grandparents have been ignored by the Children Act and its amendments. The second point is that successive governments have considered whether grandparents should be given the facility to apply for a Section 8 order in their own right, and have decided that this is not appropriate. And we're not just talking about this most recent government, successive governments over the years. And essentially what they're saying is that nothing's going to change. And there is a tremendous amount of backup for grandparents and their so-called rights on grandchildren. And support groups like the one I've just referred to meet, and there is an element of campaigning about to start. Because it's for all intents and purposes, it's a political decision that will need to be made. The third point is that as a result of most cases being as it is, most cases require a grandparent to make an initial application for permission to file a Section 8 application, which creates a two-stage process. So you have to apply for permission first, and then if you're granted permission, then of course you can move on to the substantive application. I had a lady email me just over the weekend about the fact that permission had been turned down and wanted to know where to go from there. And so it was a fairly distressing sort of request to make, because unless you get permission, you cannot move forward. So you have that two-stage process. There are exceptions to this two-stage process where a grandparent can make an immediate application. But I have to say, and we'll reveal those in a moment, is that these are quite limited. So as a general proposition, the two-stage process applies to most people. The thinking behind this two-stage process is to filter out inappropriate applications as a protection against interference in the child's care, comfort, and security. And so I suppose what the government would say, and no doubt the judges would say, is that if you gave grandparents the automatic right, the courts would be flooded with applications. Now, I don't know whether that is the case, but certainly it's a filtering process left to the judges and the lay magistrates to make a decision on that initial application. And the final point in terms of the current situation is that an application is unlikely to succeed if there are other proceedings currently in place. Now, the sort of situation I can think of is when a father is making an application for an order for him to see his children, and his own parents, that is the grandparents, want to see the children at a different time. In other words, they want additional contact over and above what the son is having. And the court is likely to see the grandparent's own application as a duplication of the father's application, as there is no reason why the children cannot see the grandparents at the same time as their father. And that's in the case of Re W. And of course, that goes back some time to 2005. Now, what sort of situations are we talking about in terms of grandparents? And let's look at those individually. The first is where there is a need for the grandparent to acquire parental responsibility. It could be that the grandchild has been living with a grandparent for some time, and he or she is unable to make important decisions on behalf of the child. So, for example, there has been a visit to a hospital, and the hospital has, understandably, queried their right to make a decision for the grandchild. And the grandparent may say, but he or she has been living with me for years. And of course, the hospital is saying, well, it's those who need parental responsibility. And you will know that one of the issues over parental responsibility is the fact that somebody needs to make an important decision. So grandparents may come to you and say, a child has been living with me. I want to acquire parental responsibility. What do I do about it? Which is what we're seeking to address this afternoon. The second is when the parents separate and the grandparent has been refused any contact with the grandchild. You can envisage that situation where parents break up. It may be that the relationship between the grandchildren and the grandparents is fine, and the parties both recognise there is an ongoing relationship that's in the interest of a child. But sometimes, perhaps one could say more often, when parents split up, the relationship between the grandparent and the grandchild is affected. The third is when the parents refuse the grandparent any contact, and that's contact with the children. It could be that there has been a fallout between the adults and the grandchildren are caught up in the dispute. The end result is that the parents refuse the grandparent any ongoing relationship with them. And in the support group that I attend, it is amazing how many situations where there is a fallout between son and parents maybe, and it's been decided that part of the dispute incorporates the fact that because they don't want to see their parents anymore, the grandchildren shouldn't see the grandparents either. And so those are the three situations. The final one is when an application is required as a result of social services becoming involved with the family. The parents may be unable to care for their children safely, and social services look to the grandparents to care for the children, maybe in the short term or even in the long term. And for those of you who do public law proceedings, will no doubt recognise that grandparents feature very heavily in many care proceedings cases, because effectively the grandparents step in to care for these children. If a grandparent does wish to make an application to the court, and I always say to clients, try and resolve it without going to court for obvious reasons. But if they do go to court, what sort of orders are available to grandparents? And let's look at those individually. A child arrangements order, which could involve either the living with or being able to see or visit or have contact with a grandchild, which is probably the most common feature within grandparents' application. The second is if a request is made for a special guardianship order. And of course, they're common in public law proceedings, but are available as private law applications too. In fact, when they first came into being, they were technically, and still are technically, private law proceedings. But for those who are practicing in public law, special guardianship orders frequently come into the courts in terms of any final order. The next one is a specific issue order. That is, for example, where a grandparent wants to take their grandchild away on holiday abroad and the parents will not consent. It could be all sorts of situations which would arise. It may be that the children are living with the grandparents and they want to take the child abroad and they object, in which case they need to make a formal application to the court. The next one is a prohibited steps order, which is, for example, to prevent a parent from removing a child from their school or visiting school. That is a remarkably common situation. I'll give you a situation that I was involved in what seems like some time ago now. But a grandmother came to see me and she'd been served with a prohibited steps order. And she went on to tell me that she'd had a fallout with her son and daughter-in-law, and she wasn't able to see the 3 children involved, despite the fact that there had been an ongoing relationships until that time. And one particular child was a bit older, was 12 or 13 years of age, who contacted the grandmother, and said she would like to see her grandma at school during the luncheon break. And that happened for a few weeks. The parents then got to know about it and was furious about the fact that the grandmother was seeing the 12 or 13-year-old girl behind their back, and therefore sought a prohibited steps order against the grandmother. And that was successful. I advised the client to apply for a child arrangements order for her to see her 12-year-old granddaughter. But in the end, she simply couldn't afford to take it to court. But it was a very sad situation. But it could be that the prohibited steps order could be made not just against a grandparent, but also on behalf of a grandparent. And the final area is one of adoption by a grandparent. Now, this is likely to be very rare, but technically it is possible. If a grandparent is seeking the court's permission to file a Section 8 application, the authorities are found in the Family Procedure Rules 2010 and Part 18 and Practice Direction 2010 18A. So you need to look at that before taking matters any further. If you receive instruction from a grandparent to proceed with an application, then the process will be relatively straightforward, albeit somewhat complicated in terms of knowing exactly what to do in terms of process. Now, of course, we have litigants in person that sometimes take out applications, but on the assumption that the client has come to you, let's look at the starting process. So for Section 8 orders, there will be an obligation for all parties to attend for mediation. Unless your client is exempt, such as an emergency application or domestic abuse, there is no choice but to attend for mediation. If the parties do not attend for mediation, they face the likelihood of an adjournment of the first hearing to attend for mediation. Now, if mediation has been attempted and proves unsuccessful, your grandparent client can then proceed with the application for permission to file a Section 8 application. In practice, you'll file both the application for permission and the substantive application at the same time. The court will fix a date for the permission application to be dealt with. All parties with parental responsibility will be served with the application and invited to attend that initial hearing. If permission is granted, the Section 8 application will proceed and a further date given to hear that matter. It's worth noting that no safeguarding checks will be undertaken by Cafcass in relation to the permission, at least at the permission stage. Safeguarding checks will only take place once permission has been granted. Once permission is granted, the likelihood is that the court will fix a hearing date for the Section 8 application and activate the safeguarding checks in the meantime. Now, it's interesting because when I've raised it in the past, the solicitors around the country have said, well, actually, in our area, it is somewhat different. What the court will do is fix a hearing date to deal with both the permission application and the substantive application. They even go as far as organising the safeguarding checks. So what I've just said applies in the area where I practice, but I know there are parts of the country where they seem to short circuit the whole situation by having everything on the same day. I'm not entirely sure how it's practiced, but it's interesting. About 3 or 4 years ago, I was representing a father in an application that was taking place in East Sussex. It was a remote hearing, and I was in Nottingham. My client was in Truro in Cornwall. The hearing was in East Sussex, and the grandparents who made the application were in East London, as were their solicitors. And I assumed that the permission application was simply in isolation. As it turned out, it wasn't. And it was as it was in some areas where everything was combined together. And even Cafcass had undertaken some safeguarding checks. So the general principle of having separate hearings will depend on the area concerned. And sometimes I've been proven quite wrong on that by suggesting that whilst it's a first court appointment, it is sometimes a first court of court appointment to deal with both. There are a number of situations where the grandparent will not be obliged to seek the court's permission to file a Section 8 application. Let's just explore these together. The first is if the child has been living with the applicant for 3 years or more, which could be a grandparent. Now, of course, that it could be when you're making these applications for permission. It could also be an aunt or uncle, or indeed anyone else. But the starting point is that the child has to be living with the applicant for 3 years or more. Watch this space for further information about the grandparents. The second is if the child is in the care of the local authority and the local authority supports the application. So it could be that the local authority are looking after them and the grandparent wants to make their own application. If that's the case, then of course the local authority will clearly have a view on the matter and will inform you as to what that is. The third is where all the parties with parental responsibility consent to permission being granted. So to some extent, that's a practical issue because you're filing the application and you would need to make it clear in your initial application that all those with parental responsibility are agreed that the substantive application should proceed without the first stage taking place. The next one is when the applicant is a guardian. In other words, somebody who's been appointed to care for a child under a will and the parents have died following the making of that particular appointment. Or the applicant is a special guardian, and we'll be looking at special guardianship shortly. The next one is where the applicant is already named in a child arrangements order providing for residence. In other words, living with. Now, of course, in today's world, they're the sort of orders that would take place. But if there's been a previous order and the grandparent wants to make an application of some sort, then the applicant is already named in the child arrangements order, then of course they don't need the permission of the court at that stage. The next one is when the applicant is a foster parent and the child has been living with him or her for 1 year or more. And finally, the applicant is a relative who has cared for the child for 1 year or more. Now, of course, you look at the first one of 3 years, and you look at the last one, which is 1 year. And of course, if you're a grandparent, you will clearly come within the confines of a relative. And therefore, the advice you'll be giving to your client at that first interview, having ascertained how long the child has been living with the grandparent, 1 year is the due period. The definition of a relative is pretty wide and clearly includes the grandparent. So in our case for grandparents, the qualifying period is the 1 year. Now, your application for permission to file will be sought either in two circumstances. The first is in existing proceedings, possibly where parents are in dispute over their child, or perhaps more commonly, in care proceedings. The situation that I had not so long ago was that a father was seeking to have contact with his son, and the grandparents, notwithstanding what I said about duplication, had applied for their own contact. One of the reasons is that there was an allegation of domestic abuse, which could delay the process. So the grandparents made their own application, but there were, of course, existing proceedings because the father had made his own application, and the court consolidated both. What was also interesting was that the grandparents had contact with the grandchild earlier than the father did. He had indirect contact, but the grandparents had direct contact. So in existing proceedings, that can arise, even in private proceedings. But of course, the most common one is in care proceedings. So you could make an application whilst the local authority are taking proceedings through the family court. And the second is one of freestanding application, often used in private proceedings, which is probably the area that you come across them more often, unless, of course, there are care proceedings. If there are already ongoing proceedings, an application by a grandparent can be filed within those proceedings using Form C2. If there are no existing proceedings, the application will be a freestanding application, and both Forms C2 and C100 will need to be filed. Now, it's worth remembering, and this applies particularly to public law proceedings, that the local authority cannot apply for a child arrangements order on behalf of a grandparent. The grandparents have to apply themselves. Furthermore, the local authority foster parent can only seek permission if they have the local authority consent, or he or she is a relative, or the child has resided with the applicant for 1 year or more. In practice, if the local authority want a grandparent to obtain a Section 8 order, they should support the grandparent in seeking their own order, that's the grandparent's order, preferably by funding their legal costs. That way, the grandparent can obtain their own independent legal advice and representation with the financial support of the local authority. Now, that's all very well in practice, but we're living in a world where there is acute austerity within local government finances. And I've sometimes said in more recent times, would you support my grandparent client in making an application? Because it will save you a lot more money in terms of foster care and the local authority say, we simply don't have any money to support grandparents anymore. More about that in a moment. Now let's look at the application for permission to file in more detail. Section 10.9 of the Children Act 1989 sets out a short checklist of what the court will consider when dealing with an application for permission. These are, first of all, the nature of the proposed order. In other words, what order is your client seeking? The applicant's connection with the child. In our case, a grandparent. Risk of disruption or harm to the child is another factor. If the child has been living with another adult, what are the consequences of any move for the child should your client's application be successful? Or alternatively, if the child is already living with a grandparent, why the court should change this arrangement? It's like the status quo argument. If the child is in the care of the local authority, what are their plans for the child? And finally, the views of the parents themselves, remembering that the parents have every right to be heard on the application. Having gone through this, what I describe as checklist, the court has in the past made it clear that the list itself in section 10.9 is not exhaustive. The words particular regard implies that there may be other factors for the court to take into account when dealing with the permission application. One example may be the prospects of success of the substantive application. In the case of Read B in 2012, the court said that the application must be arguable if permission to file is granted. But even if it is arguable, there is no guarantee that the application for permission will necessarily be granted. The court will, of course, take into account all factors. And it's amazing how many other factors come into play when a matter comes before the court. And sometimes grandparents raise some very interesting points. Now, in Section 8 applications, the welfare of the child test always apply. What's best for the child? However, this does not apply at the permission stage. It will be a factor, but not a determining factor. If that's the case, then where does that leave us? The court will, of course, take into account virtually everything, but the question of permission for is something to be determined by the court. So if the permission stage doesn't involve the welfare of the child, how does it work in practice? And the cases of Re A in 1992 and G and Kirklees Metropolitan Borough Council in 1993 sets this out clearly. That the welfare of the child is not paramount, but it is a consideration. All grandparents' application will be taken seriously, or at least that's the theory behind it, and I'm sure that is the case. Articles 6 and 8 of the European Convention of Human Rights gives grandparents the right to a fair trial and respect for family life. Whatever the nature of any application by a grandparent, the court is under a duty to give it a careful consideration. In the case of Re J in 2002, the court held that the minimal essential protection of a grandparent's human rights was that their application should not be dismissed without full inquiry. A feature that often comes up in grandparents is the question of age. You may have heard that within applications yourself. It's sometimes argued that grandparents are simply too old to care for a child. And one particular case that I refer you to is the case of Re C, as you'll set out in that list, in 2009, where the Court of Appeal warned lower courts against making assumptions that grandparents cannot provide proper care because of their old age. Age will be a factor, but not necessarily an overriding factor. Consider this scenario is that it may be the local authority who are involved, but it may be another party where the grandparents step forward and say, I want to care for my grandchild. And the response is, how can you possibly care for a young child? You're in your late 60s, early 70s, or even older. There's no way that you're going to be able to care for this child. And what we see seems to be saying is that, yes, of course, there will be factors, but it could be that a 60 and 70-year-old are very well in terms of health. Everything is provided for them, and they could necessarily support a child and care for the child. And that happens more than we sometimes think. I did do a case some years ago involving a child. I was actually for the mother in care proceedings, and the local authority was seeking to remove the child from the mother. And the grandparents stepped forward and made an application for them to care for this child. She was about 5 or 6 years of age at the time. And the automatic response was, well, how could you do that? You're in your 70s. It wouldn't be fair on the child to be placed with you because you don't know how long you're going to be with us for. And what they decided to do is to have a family arrangement whereby one of the grandparents' other children had developed a strong relationship with the 5-year-old. And they were able to put forward a plan whereby they were able to say, we at the moment are very well. But if something happens to either of us, or indeed both of us, there is, if you like, a plan B whereby other people could step in our place and they would develop a relationship with them. And so I often say to clients, if they come to see me and they bring up the issue of age, I sometimes say, have a plan B. See whether it's possible for you to counter the local authority or indeed the opponent's argument by saying you're too old. And if you come with a plan B, it will work. Now, in the case that I referred to where it did work, the guardian who was looking after the interest of the child was very impressed. She said they clearly had a plan B, and whilst age is a factor, it wasn't an overriding factor. And so far as I'm aware, everything worked out very well. And this, to date, the grandparents are still alive. But if they, for some reason, are no longer with us, then of course Plan B will come into effect. So that's one suggestion that we have to consider. I did another case involving 2 grandparents. There was no conflict of interest, and both grandparents put themselves forward for different children. And the local authority argued strongly that they were too old. And the court dismissed the local authority's position and had enormous sympathy. Sadly, in the end, the grandparents didn't have a child arrangements order, but it went all the way and it looked as if they would. So the case of Re A in 2015 gives a helpful summary of what the court is looking for when deciding on a permission application. And we haven't got beyond that yet. So first of all, that every case is fact specific. That section 10.9 sets out a checklist, but remember, it is not exhaustive. All material facts will be taken into account, including whether there is an arguable case. And finally, the welfare of the child is relevant, but not a paramount consideration. Should the court refuse a party permission to file an application, there is a duty on the court to give reasons for that decision, as stated in the case of T&W in 1996. Let's now look at the process by which an application for permission on behalf of a grandparent is made. All applicants will need to attend for mediation that we've indicated already, unless they're exempt from doing so. For example, where there's domestic abuse or there's some other reason for, say, emergency, mediation will take place and grandparents are no exception. As we've already said, if mediation is unsuccessful, your grandparent client will need to file an application for permission. Usually, this is by using Form C2 together with a Form C100. It's important that written reasons for an order are set out in detail. A legal advisor in the family court commented to me recently that solicitors tend to assume that court will read between the lines and thus give the briefest of detail. This is not the case, and there was a call to solicitors to give as much detail as possible. This will help the court when dealing with the application at an early stage. In fact, it could be a means by which you could avoid the permission stage hearing. Whilst it's not necessary to file a separate statement, there is no harm in attaching an additional sheet to the application form if you run out of space. Enclose a copy of the draft order. It's quite straightforward, as we've got the CAP forms, and CAP forms are pretty straightforward to use, and most courts are readily accept them, and indeed most of them do nowadays. If there are allegations of violence or safety issues or matters of confidentiality, include Forms C1A and C18 with your application. If the proceedings are already running, then Form C is adequate. A court fee is payable at the time of filing your application form. It could be that your client, because of the fact that they're on a low income, is exempt from paying the court, largely down to the fact that their finances are limited. This is definitely worth exploring with your client because it avoids what I describe as a pretty high court fee. The court fee is a one-off payment. If permission is granted, no further fee is payable on the filing of the substantive application. Your grandparent client cannot gain parental responsibility without having a court order. There is no such thing as parental responsibility order for a grandparent. The usual orders would be, as indicated already, child arrangements order or a special guardianship order. Parental responsibility will last as long as the court order is in existence. If the court order comes to an end, so does parental responsibility. Finally, your grandparent client will need to be advised on how their application is to be funded. I've touched on this to some extent already, but the first thing is one of legal aid. Legal aid funding has been abolished for most cases involving a grandparent. If your client has been subjected to domestic abuse within the legal aid provisions, legal aid may be available. These are likely to be rare for a grandparent case, sadly. Although there is talk about kinship being granted legal aid, and that could possibly include grandparents. So your client will almost certainly need to consider raising legal fees personally. This can be a barrier to many applications. If the local authority is involved in some way, then of course it may be that they will agree to provide some kind of funding for your grandparent client to enable matters to be put before the court as private proceedings. Some local authorities are more generous than others. Some will be willing to pay the full costs, while others will limit payment to a couple of hours legal advice only. This needs checking at an early stage. If your client has been in touch with the local authority, I would suggest that you make contact with them yourself to investigate whether they will pay your fees on any application by a grandparent, and if so, how much. What I'd say to you is, and I've said this already, is that the local authority are not known to be generous, and they simply respond by saying we simply don't have any money to be able to fund that. Now, of course, the other option would be for a grandparent to act as a litigant in person. And of course, they could do so quite easily if they wanted to. And what we do know is that litigants in person appear in the family court on a regular basis. In fact, there's something like 70% of cases, certainly children cases, involve at least one litigant in person. So that brings us to the end of a grandparents' application in private proceedings. It goes without saying that disputes over grandchildren should be settled outside the court arena, if at all possible. Discussions within the family, and if necessary, mediation, are the best way of resolving such dispute. It's only as a very last resort that disputed issues should come before the court. And I think we all need to bend over backwards to avoid that happening, because what it simply does is raise the temperature between the parents. And I've known a number of cases where the court have thought that the application has been treated with an element of sympathy, but then the court have simply said, well, if we granted permission to file the application, how would it work in practice? How would you relate to the parents and so on? And it was decided in the end that it wasn't appropriate to grant permission, because if a private law order was made in favour of grandparents, it simply wouldn't be workable. So turning now to public proceedings, where the local authority social services department are involved with the grandchild. And you may have come across this yourself. Let me just sort of check my timing. Okay. If a child is at risk of significant harm, the local authority will take steps to protect that child from such risk. This will sometimes mean that the child is removed from the care of the parents and placed with an alternative carer. This can be to place a child with a paid foster carer, often by way of a care order under Section 31 of the Children Act, sometimes by agreement with the parent under Section 20 of the Children Act. If an alternative as an alternative to a foster placement, the local authority are under a duty to consider placing the child with a kinship carer. And that's as set out in Section 22C of the Children Act. A kinship carer can be a grandparent, and they are often the first port of call. This placement can take place under a child arrangements order, maybe for a fixed period, during the care proceedings. They may also be assessed as foster parents. If care proceedings are running, it may be to your client's advantage to care for their grandchild under a child arrangements order. The child arrangements order will give the grandparent parental responsibility, even for a short time, and will also give them access to legal aid, and that's done on a non-means, non-merits basis, because legal aid is available for anyone who's got parental responsibility, and of course by way of the child arrangements order that would exist. And they will become parties in the proceedings and have access to all the papers and able to attend court with their own solicitor and be actively involved in the care proceedings relating to their grandchild. The local authority will, of course, need to undertake a viability assessment of the grandparents to satisfy themselves and the court that the grandparent is a suitable carer. Some local authorities may be more willing to consent to the grandparent having party status or being granted a child arrangements order until a viability assessment has been completed. My own experience is that local authorities very rarely are able to agree to any kind of order until that assessment has taken place. But I have spoken to solicitors in other parts of the country who say that their particular local authority is far more flexible. Some local authorities take the view that it could be in their interest for the grandparents to be legally represented in any case. So that's the position with regard to care proceedings. So grandparents of looked after children, let's say this, that if a child is living with a foster carer under a care order, the grandparent does not have automatic rights. Just go through this particular slide fairly quickly. Let me just set out for you. So if the child is living in foster care, the grandparent does not have an automatic right to see the grandchild. If the local authority are not willing to allow the grandchild contact with the grandparent can apply to the court within the care proceedings for an order under section 34 of the Children Act. And that's permission to apply for an order is still necessary. My own experience is that a good compromise could be for the grandparent to see the grandchild at the same time as a parent. And that can be quite tough. We're thinking about rights of grandparents. But if a child is taken into care and they don't see the grandchild, it can be distressing for the grandparents as well as the parents themselves. Much has been said in recent times about special guardianship orders. These, of course, are the invention of Section 115 of the Adoption and Children Act 2012. And orders such as these have been available since 2011. So we're going back some years and have increased enormously over the years, particularly in public law proceedings. So let's have a sort of sweeping view of what is a special guardianship order. It's a halfway house between a child arrangements order and an adoption order. The order is available to anyone other than a parent of the child in question. In our case, a grandparent. It's often used by the courts to secure a placement with a grandparent. The child concerned remains in the community and often within the family with your grandparent. For parents, it means that they can usually keep in contact with their child. The carer, in our case the grandparent, becomes a special guardian. As a result, the special guardian will acquire parental responsibility so long as the order remains in existence. If the special guardianship order comes to an end, so does parental responsibility. One consequence is that it avoids adoption, where the grandchild would cease any formal relationship with the family. One special feature is that the order gives the special guardian greater control over the care and upbringing of the child at the expense of the parents. The special guardianship order also carries with it the right to receive help from the local authority in the form of counselling and other support, in fact. The special guardian can also seek financial help from the local authority. There is a means test involved, and that's undertaken under the Special Guardianship Regulations 2005. I would advise that a grandparent should not agree to a special guardianship order until he or she is clear what help they're going to be receiving. And I've been involved in court cases where everything's set up for a grandparent to be granted a special guardianship order. The court have called the case on, but there's been no proper provision for finances, certainly established on a proper basis. So it's always been my practice to ensure that all parties know exactly what the responsibilities are, and more particularly for grandparents to know what financial support is available as a special guardian. Sometimes grandparents don't want to receive any support because they don't want to undergo a means test. And I had that on one occasion. It surprised me a little, but nevertheless, they were quite happy simply to look after the child without any financial support. And so that slide sets out the sort of support the local authority can give: counselling and advice, access to support groups, therapy services, respite care, financial assistance, and so on. How does the grandparent obtain the special guardianship order? Written notice needs to be given to the local authority by your client. A grandparent may ask you to deal with the matter on their behalf. This gives the local authority 3 months' notice of your client's intention to apply for a special guardianship order. There is no set form of notice, but I would suggest that it needs to contain details of your client's name and address, date of birth, address of the child, your client's relationship with the child, and a request that the local authority undertake an assessment to enable your client to apply for a special guardianship order. This notice will trigger a detailed assessment of your client. So you'll need to prepare your client for a full inquiry, which will look at the family history, health, ability to care for the grandchild, and so on. Then a report will be presented to your client, who may wish to make an application for a special guardianship order at that stage. So the application to the court will not take place, usually, until the report is available. And the court can make a special guardianship order of its own motion, provided that the report is available to consider. It will not make an order unless a report is available. And the special guardianship order will continue until the child reaches 18 years of age, unless varied before that date. The parents will continue to have parental responsibility, but in a restricted form. In practice, the special guardian can make most decisions regarding the child to the exclusion of the parents, with the exception of changing the child's name and moving abroad for more than 3 months. So if you're involved in care proceedings, and care lawyers will know this very well, is that sometimes you say to a parent, the grandparents are seeking a special guardianship order, but I do need to tell you the impact it will have on you, that whilst the child will be living with the grandparents, they will have control over the care of the child, and you will not have very much control at all. Are you understanding of that? So a grandparent can make a private application as well. And even though we tend to think of it in public law proceedings, you're entitled to do that. And I'm just going to move through the slides on private law because they don't come up across them very often in my experience, but it's worth knowing, being aware of. I just want to deal with a number of issues with regard to changes to special guardianship. And I think this is important, is that the president of the family division has recognised that special guardians have not been given the same level of support and training as foster carers or potential adopters. Yet at the same time, they are being asked to look after a child throughout its minority. This has led to a series of recommendations being issued by a working group set up to review the position of the special guardianship. The report of the working group and recommendations was issued on the 15th of June 2020. Now, whilst the report is lengthy, the main recommendations were, first of all, before special guardianship order is made, there should be a more robust and more comprehensive assessment and support plan, and an emphasis on contact. Better preparation and training for special guardians. Reduction of the use of supervision orders with special guardianship order, which tends to be the case, and that's certainly been reduced. and a greater emphasis on parental contact. Longer term recommendations include the possibility, wait for it, of legal aid for those applying for special guardianship, and the creation and the use of an interim special guardianship order. It will be interesting to see whether many of these come into place in due course. There has been a certain amount of movement on this. And then in terms of discharge and variation of guardianship orders, so unlike adoption order, court may vary or discharge a special guardianship order. However, an application to discharge the order cannot be made by certain people unless the court has given them permission to do so. So we're back to the question of permission. Now, these people include the child concerned, a parent or guardian, a step-parent, or any other person who's had parental responsibility for the child immediately before the special guardianship order was made. And so the parents who wish to apply for a discharge have to go through two stages. The first stage is that a parent who wishes to obtain permission to apply to discharge the special guardianship order has to show a significant change. If they can't show a significant change, their application will fail. If they can, the court will then decide at the stage 2 whether leave should be granted based on a realistic evaluation of the applicant's prospects of success in the context of the welfare of the child. And the prospects of success must be real. The child's welfare is an important factor, but is not the paramount consideration. And I've given you in the notes details of certain cases where the court have had to look at the matter carefully and said whether this is appropriate or not. And in the particular case that I've given you, the case of Re M in 2021, the judge simply got it wrong. And the bar was set too high. And the judge said on appeal that the judge who dealt with it at first instance simply expected the impossible to happen. So it's worth looking at that case, but in a nutshell, what we have to say to ourselves is, has there been a significant change of circumstances? And if so, is it possible for the court to change it? I'll give you a sort of situation where we come across a change, maybe a discharge, maybe a variation, is that say a child was removed from the care of a mother who had, say, a drug addiction problem or alcohol problem or some serious issue that prevented her from caring for her child. A special guardianship order was granted in favour of her mother, the grandmother. Time passed, a mother's position improved immensely. And the mother said, I've now come out of all the problems I've had. I now want the child to be returned to my care. And the court said, in view of the circumstance, there has been a significant change of circumstances. There will be a detailed inquiry. And on the basis that the mother has improved immensely, and there has been a significant change of circumstances, and she can care for the child, the court are likely to grant that application. But every case is fact specific. Just a few things just to bring matters to an end, and I see I'm running out of time fairly rapidly, really. Meet the clients, try and resolve them with the family, consider mediation, permission to apply, does it fit the criteria, orders being sought, what forms are going to use, attend the court hearing. And then finally, I have written a book, which is now in the 2nd edition, on the rights of grandparents. If you're interested, please check it out. Thank you very much indeed. Sorry for overstaying my welcome. Thank you very much.
You're very welcome, Stuart. You are forgiven. And it was so interesting. It was well worth you continuing till the end. So thank you very much indeed for that very informative and entertaining talk. Well, we're coming towards the final tea break of the day, and I'm sure you're all gasping for a tea or a coffee. So let's take a break now. And well, we're supposed to be coming back at 10 to 4. That's 10 to 4 now. So let's come back at 4 o'clock. And Andrew Otchie then will be waiting to join us. And so again, thank you very much, Stuart. And goodbye until 5 o'clock, everybody. Thank you. Hope you're back. And the witching hour of 4 o'clock has arrived. And waiting in the wings, we have an old friend of mine, Andrew Otchie of 12 Old Square, Lincoln's Inn. And he's going to bring these proceedings to a close. We've had a long day, but last but not least, Andrew, we're looking forward to hearing about Cafcass, not everybody's favorite organization, but I'm sure you'll have some interesting things to tell us about that august institution. So over to you, Andrew. Thanks.
Thank you, Richard. And can I just check you can see and hear me and have my slide in view?
Well, yes, I think everything is in order, and the first slide is there with the title.
I'm grateful. So thank you very much for the invitation to speak, and I see many friends and colleagues online. And I appreciate your patience in listening to me as the last speaker of today. I've listened to the other speakers and hope I can keep up with the very high quality and bring us to a conclusion. I'm happy to take questions as we go, and I'll try to work those into the talk. So any comments, as Richard has already made, about Cafcass, good, bad, everything, then please do let it be known. So our chambers have seen a marked increase in family work over the past few years, and this talk is born out of recent experiences, reflections, and what I think is an important and reoccurring theme in practice. Usual disclaimers apply. Nothing I say is legal advice or should be taken that way. But we'll talk about Cafcass, its background, some previous legal challenges, the role of a Cafcass officer, some thoughts about the context and how we might approach a challenge to a Cafcass officer's evidence in practice. And I hope to bring us to the conclusion at 4:30. So Cafcass, of course, is the Children and Family Court Advisory and Support Service. Its objective, according to its website, is to look after the interests of children involved in family proceedings. And of course, what that means is that it does safeguarding, giving advice to the court, providing representation of children in family proceedings, providing information and advice and supports children and their families. And of course, if required in proceedings, Cafcass officers will work with children and represent them as guardians. They commonly produce reports as well, and those reports are required when there can be disagreements as to contact arrangements. Now, they have a long history because family courts have used social workers and their services to assist in investigations, and they were formerly known as court missionary, and it's a practice that goes way back into the 19th century. Now, Cafcass, of course, came into existence on the 1st of April 2001 as a non-departmental body, then part of the Lord Chancellor's Department. But before that, the social worker services were provided by the Probation Service. And Cafcass is essentially a creature of statute. Now, 22 years old, makes it slightly older than some of the children it's involved with, not that much older, and part of Generation Z. So some of the terminology then, and we'll look at some of the cases, some of the older cases, and the Cafcass officers have been referred to by different names, different terminology, all the same thing, and they're now, in fact, formally, according to the statute, officers of the service. It's their proper title, but referred to as Cafcass, officers in practice. But they've also been known as children and family reporter, CFR, also as children's guardians, parental order reporters and reporting officers. And they slightly different things, but to say they're all now amalgamated into the term Cafcass officer. And in fact, what the Criminal Justice and Courts Services Act 2000 did was to replace those terms formally with the term officer in the service. And you also have Cafcass Cymru, which is the service in Wales, and that applies when a child is resident, or there's an argument about the child's residency in Wales. So from 2001, in the early 2000s, its aims were laudable, but it soon ran into difficulties. And in fact, a House of Commons Public Accounts Committee produced a report in 2010, which described Cafcass as then not being fit for purpose. And the concerns were that there were essentially problems, not with the quality of reports, but with the caseloads that Cafcass was being asked to carry out. And there were risks that its work simply wasn't being done. So we had at quite an early stage of its existence a practice guidance issued by the then president of the Family Division, Sir Mark Potter, and you see the reference there. It is only guidance that applied. But what it was essentially to do was to ensure its work was done in close working relationship with the courts and the organisation, timetabling, prioritisation of cases, and essentially it was a short-term measure developed with the agreement of all parties, just to create a working framework. And then by the 1st of April 2014, Cafcass becomes part of the Ministry of Justice. In recent years, well, of course, its work carries on, and there has been a significant impact on the family justice system by Cafcass, and its work is essentially this: to try to resolve disputes before they get to court, and its work is inquiry-led rather than having an old adversarial system. So, of course, a lot of work is done by Cafcass to try to resolve disputes and to try to have orders that can be agreed between the parties. And, of course, it should be said, another major part of Cafcass's work is to do various courses, the Separated Parents Information Programme, improving child and family arrangements, services, and domestic abuse perpetrator programme, DNA testing as well, services run by Cafcass in addition. Judicial review. So now I'm going to move on to look at some of the challenges that there have been to Cafcass, and some of those have come by way of judicial review. So 3 cases there, and the first one I refer to is ours. It's judicial review brought by the official solicitor, R, E, J, and K, all minors, children, and they judicial reviewed Cafcass. And essentially the claim was this: those were typical cases, and those children needed a guardian. The case has been referred to Cafcass. There hadn't been a guardian appointed, different points in the different cases, but there were typical delays, 3 months, 7 months, 4 months. And they contended, I think they had some pretty good arguments. There was a breach of Cafcass's duty to them because they hadn't been appointed guardians in those lengths of time. And in the various care proceedings, of course, as we said, the timetabling and conduct of care proceedings are very tightly governed, and there should be no delay. The principle. And they argued that there should have been the appointment much sooner. These care proceedings were front-loaded, quasi inquisitorial, and there should have been strict judicial controls. The denial of representation at the beginning meant that there would be prejudice and the work would be done towards any stage. So they said that there was the ability for Cafcass to run its timetables, but they were simply doing this too late. And Cafcass counter-argued to say that, well, yes, they agree they have these duties, but it was up to them to do so as was reasonably practicable in regard to its resources and commitments. So, of course, the application for judicial review failed, as you might well imagine. And what the court said, and it's again, it's the High Court that's sitting as a divisional court, Lord Justice Mumby and Mr. Justice Thurwell. Well, it's a good decision to read because it gives you the statutory framework of Cafcass. And again, that's under the Criminal Justice and Court Services Act 2000. So those obligations are there, and it's section 12 in particular that gives Cafcass the duty to make provision for children to be represented in proceedings and to make provision for the performance of its functions to be carried out. So again, in other words, it has statutory functions. But as you might imagine, it was for Cafcass to decide how it was to do its functions, having regard to its resources. So it couldn't be forced into giving particular timetables. Essentially, its argument that it could do so as was reasonably practical succeeded, and there was nothing irrational about that stance. And there's a comment towards the end of the judgment that says this is a case about resources, or rather the inadequacy of the resources made available to Cafcass to enable it to perform its vitally important functions, functions which must never be forgotten are directed to protecting and enhancing the welfare of some of the most vulnerable and damaged in our society. Charles J. concluded his judgment in the earlier Cafcass case by referring to strong arguments in favour of the view that Cafcass should receive funding that is sufficient to enable it to make officers of the service available for appointment as children's guardians in specified proceedings on or within a very short time after its receipt of a request to do so from a court. It would seem, unhappily, that this has been ignored. It is surely a serious question for government and parliament whether the state of affairs revealed, and not for the first time, why these cases can continue to be tolerated. So you can see there great sympathy for Cafcass and its work, and that it should have the resources that it needs to do its job. So that case was appealed, and the next case is essentially the same case, but at an appeal level. Lord Justice Judge, then Chief Justice, and Lord Justices Richards and McFarlane in June of 2012. And again, they look at the statutory framework, the natural reading of section 12 of the 2000 Act is the general framework of the operation for Cafcass. It doesn't create duties to specific individuals, and essentially they say this is impossible to define a moment in time in which the individual duty would bite. So the case was dismissed on appeal, and the last case referred to there, ground on the application of register, again against Cafcass, a judicial review, Mr. Justice Charles then in January of 2003, and it was a similar argument that children in care proceedings were owed a duty by Cafcass that they had to make an officer available. And again, they said to fail to do so was in fact a breach of their human rights, and they also sought damages. But even from that time, that earlier judgment was followed in the previous cases we've referred to, then it was held no, Cafcass doesn't owe particular duty to make one of its officers available. It's a very general duty, and Parliament did not intend Cafcass as a public body to be subject to duties more stringent than those that you would consider under public law principles. So putting all that together, there is clear reasoning that Cafcass does have statutory functions which are clearly defined, but it's very much up to Cafcass how it implements them. It can't be held to strict timescales, even those are developed in practice. And again, it's up to Cafcass to be resourced by the government, and there have been no other successful judicial reviews. So the statutory context, and we've touched upon this then. So according to section 41 of the Children Act 1989, the court shall appoint Cafcass, and in accordance with rules, and those rules are now family procedure rules. There have been previous versions, but it's the current rules, to safeguard the interests of children, appointing guardians. And we move on to section 42. They have the right to take copies of records, examine records, and then under the Criminal Justice the Court Services Act 2000, we touched upon that. That's the section 12 there that says, in respect to family proceedings, in which the welfare of a child may be in question, its functions and are, and I've highlighted C there because that's what was argued about, making provision children to be represented in such proceedings. So that's about all it has to do. That was just a quick snapshot of the statutes. So Cafcass in court, and what I'm talking about now is in particular having a Cafcass officer in court, and what their role is there. So there are a number of authorities that touch on this, and they're quite old and quite varied, but one of the important ones is this then. So we have the Court of Appeal, Lord Justice, Lord Mr. Justice Wall, then in 2002, re-M, a child disclosure. And this was private law proceeding about residence arrangements for a child's parents are separated. And essentially what had happened is the Cafcass officer, and I said that the old terminology there was children and family reported, so CFR, made a disclosure. There's an argument about whether or not that disclosure should have been made. The judge said no, and the mother appealed. Her appeal was allowed because the Cafcass officer was allowed to make the disclosure. There's no breach of privacy. But there are other principles about the role of a Cafcass officer which should be of interest. And as I highlighted there, the Court of Appeal said that the officer did not act always under the direction of the judge, independently exercise independent discretion as to the nature and extent of his investigations and inquiries, and no less the manner in which he approached them. The relationship between the judge and the CFR was most obviously a collaborative one, and that's the important point there. We'll go on and look at all these principles together, but of course the Cafcass officer collaborates with the court. That's not a secret, and of course that's what they are doing. So another case that's referred to from that case is that of Cadman and Cadman, going back all the way to 1982. Again, speaking of a welfare officer, but Lord Justice Ormrod said this in terms of standing of the officer. They are not witnesses in the case at all. They are officers of the court appointed to make reports to the court. They may or may not give evidence and submit themselves to cross-examination. It is a matter entirely for the discretion of the judge as to whether he thinks that would be appropriate course or not. It does not by any means follow that in every case the court welfare officer to be treated as witnesses, whatever they are. They are not witnesses. They are independent officers of the court appointed to assist the court. And just pausing there, officers of the court, so the same language as one would use to describe a solicitor or a barrister, an officer of the court. And again, that's an interesting case because the issue is there whether a child should stay between either parent parties disputed. But here the father unilaterally obtained a report from an independent social worker who's dissatisfied with the content of the welfare officer's report. It's quite an old case again, but even then the judge doubted whether, the Court of Appeal doubted whether the judge would have had jurisdiction to allow him to do that because there was no consent from all sides and appeal was allowed because it was said that the judge below in allowing that did not dealt the matter properly at all. And again, in the case that I referred to, the redisclosure, Court of Appeal looks at other authorities, and one of those, again, was an old 1990 case. And it's this point about the CFR not acting under the direction of the judge because they do their own independent inquiries. And in fact, what they do is to gather hearsay and put that into their report. And in this case, H&H and K&K 1990, there was some discussion there in a case involving allegations of sexual abuse of a child, how the court should approach that hearsay. But Lady Justice Butler-Sloss made some interesting remarks also about the welfare officer. But even from here, it was put beyond doubt that the rules of hearsay don't constrain what the welfare officer has to say in a court. And I think many of us will recognise that the reports are essentially hearsay, but it's allowed to be so. Now, another principle is that the Cafcass officer is known as the eyes and ears of the court. And that was said in a case, Residence Order 2009. So again, it's this, that the Cafcass officer as an officer of the court will gather information, evidence on behalf of the court and put it to the court. And there's been a lot of reasoning about that. And so that's how it is. Now, also, cases there refer to situations that have come to be decided when the report is made, how the court treats recommendations in the report. And essentially this, from CV Access, Tenants of Court Welfare Officer 1995, again, all these cases essentially predate Cafcass, but they still apply. General proposition is that a clear recommendation should only be rejected after hearing oral evidence, because when their evidence has been rejected, the higher courts have decided but that should not be so unless there is clear reasoning for such a departure. I'm just speeding up a bit because see the clock is ticking. So these are principles that essentially I've distilled from reading those cases, and they're not witnesses but officers of the court, work in collaboration with the court but not directed by the court. No right of cross-examination, that's at the discretion of the judge. And again, their recommendations should only be rejected after hearing oral evidence. And I add to that with reasoning. There has to be clear reasoning for not accepting the evidence of Cafcass officer. But there may be a case where they don't in fact give a clear recommendation, and it would be then unnecessary to adjourn and to hear Cafcass officer, so they don't have to be heard as witnesses, and very often they're not. And what should also be mentioned, I think, in passing, is that the whole point of having Cafcass officers to produce reports and speaking to the child often is so that the child's voice and views are discovered and put before the court in a way that they're not embroiled in conflicts. Again, Cafcass are doing that job, and they don't hold a monopoly on their work, because of course it can be the case that independent social workers are appointed to do reports, or even charities. The National Youth Advocacy Service, which doesn't have the same statutory functions, can also do the work. So a few thoughts now on context, and I think has been mentioned today already that family law work, demanding in many ways, it has nothing to do with some of the legal principles we've been talking about, but by their nature, the family client is upset, distracted, and driven by emotion over logic. Avoiding complaints, that's what we might be thinking at the time dealing with such clients, because of the nature, again, of the cases. Time management becomes very important for everybody, including clients and delays. We've also mentioned their well-being, because we should also keep in mind the mental dexterity needed, and often acting as sponges, as has been mentioned. But at the same time, the sense of vocation, which leads us to our job, means that we are there. But Cafcass says, no, in the real world, often disputes involve recommendations by Cafcass officers which are at odds with the clients that we represent. Children being taken into care, fathers and mothers having no contact because it's deemed unsafe, or a form of contact permitted which the client simply disagrees with. And these are the difficult circumstances, and the so what is that we may well end up in a challenge to Cafcass officers' recommendations in court. As I said, as I read the authorities, there's no actually right to cross-examine Cafcass officer, and again, it's the discretion of the judge if you can do so. But moreover, the challenge is to a skilled professional who's likely to be well prepared and well motivated, and the court will be heavily inclined to accept the reasoned basis of their recommendations, and essentially challenging Cafcass officer. The type of this presentation is to be posing a challenge to what's essentially expert evidence, but there are no written questions, and there is often no alternative expert. So the challenge, how would you go about this? And these are just a few thoughts then in the brief time that we have available about how there might be challenge. And I should think about your hypothetical client who's lost contact with their child. They deserve your sympathy because they really want to be a good parent, and they're sincere but unable to articulate themselves well, and they can't progress. As Cafcass says, they can't do the relevant course. And tempests can rise, and there can be many other situations and tensions, special needs, cultural differences. Cafcass may be the guardian, or they may be the author of the report. You may agree with their reports. They may in fact be saying something entirely sensible. Your job, and you can be obliged to make a challenge. And just again to recognise the difficulty of that challenge, I think is of course the first step. But yes, the Cafcass officer, what are their qualifications, experience? Is this somebody who's a few months into their job? Are they really familiar with the work that they're doing? Are they particularly interested in their job, or can you get a sense that they, in fact, that motivation? These are just thoughts that you might bring up. And do they really have knowledge of the facts. We mentioned resources at the beginning, and it's going to be a recurring theme because we know Cafcass do work under pressure. And is this somebody who has a very, very heavy caseload? Have they spent time on this particular case? Are they confused with the facts of another case? Do they have a supervisor offering support, and so on? Have they heard the evidence of your client and now change their view? Of course, if you ask such a question, you have to be aware that often Cafcass officer might strengthen their view against the client and their interests. But at the same time, have they really thought about what comes next? Contingency planning. So yes, the child is taken into care, but what happens if the placement doesn't transpire? And this is a short notice application. Hearsay. Now, I've brought this up because, again, often reports are based on hearsay. And what is the extent of the hearsay? Is it reading somebody's Facebook page and thinking that they can't be a good parent because of something that's there? And is it really proper to attribute such views because of hearsay? So under future cases, again, just some thoughts about cases that might come up, and the challenges that there may be in appeals and so forth involving Cafcass. The relationship between Cafcass and the court. So there can be, I think, questions. Cafcass, again, as we've noted, work very closely with the court. But can they communicate with the court on an ex parte basis? Strict rules that say lawyers must copy in the other side. And then I'm sure I haven't found the answer if such strict rules would also bind Cafcass officer as officers of the court. Again, lawyers can't make comments, certainly shouldn't release embargoed judgments. That's been highlighted recently, and if the Cafcass officer were to do so, there could be a serious procedural irregularity. Societal changes, again, we're seeing things happen, screen time, meeting remotely as we are, and as we have differences in attitudes, various things, music, vaping, some of the things. Could a Cafcass officer's views conflict with those of the court and really bring an interesting case? Resources, and again, because of the lack of resources and delays that we often hear complaints about, could there be further challenges, public law challenges? We've seen challenge against Cafcass, but could it be Cafcass, as some local authorities have done so, make offensive challenges against the government for the lack of resources, so on. So there we are, 16:33. Thank you very much for listening. I am going to hand back now to Richard for our closing remarks.
And here I am, Andrew. Thank you very much indeed. You occupied what is sometimes referred to as the graveyard slot, but I think you managed to keep us all awake and indeed alive and kicking. So that was a very interesting discussion about Cafcass. As I said earlier, not everyone's favorite institution, but we do have to deal with them. So thank you again. And thanks to all the people who've sat it out for at least part of the day and perhaps for all of the day. It's certainly been a long session if you've been here for the whole of it. And I hope you will come again when we have further training sessions with AstenJ. Who knows, maybe one day we'll revert to face-to-face sessions, but for the time being, it's going to be like this. But that's better than nothing. So all good wishes till the next time. And I shouldn't leave without saying a big thank you to our hosts, Wasanta and Ajanta, and their technical support for getting us through and sorting out one or two little quirks that occurred along the way. So all the best, everybody. Bye-bye now.